Why don't you go see your boyfriend?
Yeah, he's got a nice room. You won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen to a plane.
Hi. I am just here because I didn't want to watch this ticking by myself. Yes, I am wearing the same top as yesterday. It's freaking cold and this is really warm. So I put it over this thing because I was sitting here editing. I wasn't planning on going live. And then I saw this reach 1994 and I was like, let's do this. Hey, Melissa, Lilith, and Tisha. Thanks, Steve. Yeah, it's crazy. Like literally a month. Also, I hope that the heater isn't too loud. I am in the middle of editing a video, so I'm probably not going to be like on screen for very long. I just wanted to share this part, but you can see like from July 31st. No, let's go back a bit. So I hit 1,000 on. Oh, hit 1,000 in July, I'm guessing. I hit 1,000 around 1st of July. So 1,000 to 10th of August is mad. I saw quite a few people. Adam, the lies you tell. Hey, it went up one. I'm busy editing some Judge Hillary Brayley because there were so many comments asking for more of her. And so I've currently got an hour and a half and I am an hour in and I've put up 2 other videos to go out in the next few days as well. Not from her. One is Thurston, I think. Is it Thurston? Yes, I've got a Thurston and I've got there's 2 premieres. Oh, a divorce court one. Hi, Lisa. Welcome. I clicked that off so fast. There's a divorce court one that is wild. You guys probably can't hear me when I turn this way. Oh, no, that's not what I wanted to do. 50,000 million tabs. Also, because I wasn't planning on going live, I haven't done any of the back end things that I'm supposed to do. Someone's going to make that dirty for sure. I spent the day between editing and sorting out the small laptop. that does its best, but it struggles. So now it's running a little bit faster, but it's still not the best shit. Live chat, live reactions off. Whoa! Jumped up again. How can I get a membership? I think I've gifted all of them that I have available, but there is a link here that I can share. I'm going to land up missing when it hits 2,000. Thanks, just a kidda. And Miami Bayushi. Hey, Susie. Vaughn wants to gift memberships. Can you just hold 1 minute? Be good. Oh, it dropped one. It dropped one. That is rude. I need to get a song ready. It's probably because I had this on and then I just ran away at that point. What song are we going to go with? We can't do Verdict song.
Everybody, what?
No. I think I'm going to go with Verdict. I think it's my favorite. Come on, mouse. Don't do this now. Oh, no. Phoebe? I have a friend. It's a gecko. And Phoebe wanted to have it for lunch, and I saved it, so I've now named it Breakfast because he looked like more of a breakfast kind of guy. But I suspect she may have found him a second time. Mating call? No, thanks. Phoebe Jane. No. Phoebe. It happened! It happened! That verdict song is long. Okay, should we watch some court now that that's done? That is crazy. Honestly, like a month and 10 days. And it's on 2002, the year I was born. No, I'm joking. I wasn't born in 2002. I was 12. And so someone unsubscribes. I'm not that old. We definitely need. Pizza's just arrived. And we need this judge, who I have not actually watched before. But I think he's our judge for the crazy neurosurgeon. I think it's this one. The neurosurgeon who they found his car and then it spanned 3 countries. 10 more and you'll be at the year I was born. Yeah, sure, Steve. Sure. All right, let's watch some court because I need to also edit.
Camarado, excuse me.
Judge, there's a parole detainer on this one. Just a heads up.
There is?
Yes.
So where is he going after today's arraignment? Where is he going?
He's likely going to be taken to county before his parole agent makes a determination as to how they'd like to proceed.
So it doesn't make any difference what bond I give him then, does it?
No, but I guess I'd still like you to confirm that with the detective.
Okay. Is there still a detective? Is there a parole hold on him that you're aware of, Kozak? Detective Kozak?
I am checking right now. I believe there is. I know he had multitudes of warrants.
Okay.
Multiple.
So, Mr. Camarado is here now.
State your name, sir.
Michael Camarado, sir.
All right. Calling case number 82-247-1670801, Houston, Michigan versus Michael Vincent Camarado. Appearances, please. Camarado, my apologies.
Yes. Ryan Marad, PA 3665 on behalf of Mr. Michael Camarado. We waive the formal reading. Mr. Camarado stands mute. He's been advised of his rights.
Forward a not guilty plea on behalf of your client. What is your bond argument, Mr. Marad?
Judge, ultimately, as you know, there is a parole detainer. It seems it's not going to matter what the bond gets set at. I would ask the court for personal bond. He can't get credit for time served on parole anyway.
Detective Kozak, any update?
My I do not support parole, but I'm not going to doubt what the attorney is saying. All I can say for the bond recommendation is he has multiple other department warrants for the same type of crime. They're felonies. I obviously if we let him go here, I have no reason to think that.
Sorry, I forgot to say this was actually live a few hours ago. So this judge is working.
He would ever come back for any court dates or ever come back here. Just from the prior of all these other department warrants he has, he has shown that he's not going to show up to court. So with that being said, I just want you to take that into consideration. And
always show up.
Bond recommendation is at the court's discretion with all these other things thrown. Okay, well, sir, Judge, I'm sorry. Sir, Mr. Camarado, don't interrupt when the attorney is speaking, particularly when I'm speaking. Okay, go ahead, Mr. Rod.
Judge, I apologize because if there's not a confirmed detainer, I would like to make a bond argument. that Mr. Camarado is 61 years old. Yes, there is a plethora of retail fraud convictions, but I don't see anything assaultive, at least issued on this complaint. He does have a.
So, Mr. Camarado, hold on.
Yeah.
If you interrupt him again,
Ooh.
you and I gonna have a problem. Go ahead, Mr. Murad.
Thank you, Judge. You know, he's a high school graduate. He doesn't have anything assaultive that I'm aware of, has a grown child. He has stable residence. If the court's concerned with any KPS history, I wouldn't object to GPS tether. I'm just not aware of the KPS history, but I have no reason to dispute what the officer's saying. I'm not provided with any information, but I'd ask for personal valid tether.
Is he employed?
Yes, Your Honor. He's got two jobs, one at Roberts Coney Island and one at AC Contracting.
Your Honor, if I could, just to go back to the parole, he does have a parole absconder warrant out of MDOC.
Okay.
All right, that makes it easy then. $20,000 cash surety. Probable cause, August 22nd, preliminary examination, August 29th. The reason for the cash surety bond, he has a long, extensive list, notwithstanding his two jobs, of retail fraud convictions. I mean, it goes back to the 20th century. And he's charged here with habitual fraud, but he's got way more than 4 criminal convictions on this. All right. Okay. Probable cause, preliminary examination, August 29th. Mr. Camarado, do you have any questions now regarding your bond and or court dates?
Nope. Thank you.
Have a good day.
Thank you.
All right, step over here, Tony. Step over
Okay,
here.
thank you, Detective Kozak.
Yes, sir. Thank you.
Okay. Okay. We're almost ready to start on Detroit. Let me see where we are.
I'll check soon. I thought you were gonna go with my recommendation on that ALIM, Judge. It's messing me up now.
Oh, you get over it. You're a big boy.
Yes, sir. All right, let me get you an update. I'll be right back.
Okay. Good morning, sir. What's your name? Good morning, sir. Well, good afternoon, sir. What is your name?
Hold on. Me, Fletcher.
Can you repeat that, please?
Robert Fletcher.
Fletcher. Right on time, Mr. Murad. Right on time. One question, Mr. Murad. No prosecutor today?
No prosecutors, Judge.
Okay.
Oh.
All right,
No.
calling case number 240-587-4001, Pearson, Michigan versus Robert Fletcher. Appearances, please.
Brad Marad, PA 3665 on behalf of Robert Fletcher. We waive reading. Mr. Fletcher stands mute. He's been advised of his rights.
Forward a not guilty plea on behalf of Mr. Fletcher. What is your bond recommendation?
Non-assaultive case, Your Honor. He's 67 years old. His history is also non-assaultive. He's not employed. He's a Social Security recipient. He does take a lot of medication. He suffers from diabetes. He's not received his medication, at least not all of it. Stable residence with his sister. I'm asking for personal bond, no firearms here.
$10,000 personal bond. While the case is pending, sir, you're not to possess any handguns, firearms, other dangerous weapons. Is that clear, sir?
Talking to you. Yes.
Probable cause, August 19th. Preliminary examination, August 26th. Both in front of Judge Sabrina. Have a good day, sir.
Your Honor.
Go back to Saturday and try to get somebody around there, which, all right.
Excuse me. Excuse me.
So your full name?
Nathaniel Townsen.
Repeat it, please.
Nathaniel Townsen.
Nathaniel Townsen?
Yes.
Okay. Mr. Rod, I want to put on the record. Well, let me call the case first. That's case number 200-603-8401. Pearson, Michigan versus Nathaniel Townsen.
Ryan Marad, PA 3665 on behalf of Mr. Nathaniel Townsen. We waive formal reading. Mr. Townsen stands mute. He's been advised of his rights.
Okay, Mr. Rod, what I want to put on the record, I signed this warrant as a prosecutor. So I have recused myself from it. I did speak with Judge Larry Williams, and this is a capious bond, as I understand. Is that correct?
Correct, Your Honor.
He's authorized me to give a personal bond. What was the capious bond amount in?
30,000 cash.
Okay. This is per. I'm going to give it $30,000 personal bond. For Judge Larry Williams.
Thank you, Your Honor.
Probable cause, August 19th, preliminary examination, August 26th, both in front of Judge Giles.
Thank you, Judge.
Okay, give me one moment.
Okay. Hey, Doc. Doc. Anybody put my man up 15? 15 minute walk. Anybody out there to put him up? Yeah. I got 20, 26, 22, 20 wheelchair.
Okay.
Pearson. Stand right there on the black line, say your full name. Tate. Say the what? Say your full name, sir. Eugene Pearson Jr.
Eugene what?
Gene Pearson Jr.
What's your first name?
Ronnie, Ronnie.
Ronnie Pearson Jr. Okay. All right, it's case number 220-563-2301. Pearson, Michigan versus Ronnie Pearson. Appearances, please.
Ryan Marad, PA 3665, on behalf of Mr. Ronnie Pearson, we waive the reading. Mr. Pearson stands mute. He's been advised of his rights.
Not guilty plea. On behalf of your client, what is your bond argument?
Judge, Mr. Pearson's 48 years old. This is a 3-year-old warrant. He knew nothing about it. He's off of military disability. He's an Army veteran. Those injuries on his face are due to a seizure that he had by falling down. I would ask the court for personal bond here. No prior history at all.
Is he working?
No, Judge, he's on military disability.
$10,000 personal bond. Probable cause August 19th, preliminary examination, August 26th, both in front of Judge Jefferson. You can step aside, sir.
Thank you, Your Honor.
Messing up all. What your name?
Tate. Lewis Tate.
There you go.
All right, Mr. Tate, this is calling case number 240-587-3801, Pearson, Michigan versus Kyle Lewis Tate. Appearances, please.
Ryan Marad, PA 3665, on behalf of Mr. Kyle Lewis Tate, we waive reading, stand mute. He's been advised of his rights, and we don't object to a personal bond.
Okay, court on not guilty plea on behalf of Mr. Tate. Given the nature of the offense, lack of criminal history, ties community, $5,000 personal bond, Mr. Tate. While this case is pending, you're not possessing any handguns, firearms, other dangerous weapons. Probable cause August 19th in front of Judge Kevin Robbins. Preliminary examination August 26th in front of Judge Jefferson. Have a good day, sir. Step aside.
Thank you, Your Honor.
What's your name, sir?
Griffin.
All right, Mr. Griffin, calling case number 240-587-4201. Pearson, Michigan versus Lonnie Griffin. Appearances, please.
Ryan Marad, PA 3665, on behalf of Mr. Lonnie Griffin, we waive the formal reading. Mr. Griffin stands mute. He's been advised of his rights.
We're not guilty plea on behalf of Mr. Griffin. Argument at the bond, Mr. Marad.
Judge, Mr. Griffin's 70 years old. He is a life resident here in the state. He has a stable residence with his sister. He's gainfully employed at Package Liquor. He's been there the last 14 years. His income puts him within the guidelines. He takes a lot of medications. He's received some, I believe, but not all. He understands to have no contact with the complaining witness. I don't think there's a shared residence or a relationship here. I think personal bond and no contact is appropriate. I'd ask the court for that bond.
Your neighbors.
This is, I believe, a friend of his sister, Your Honor.
Right, but they're neighbors. Aren't they?
You confirm. I'm looking, Judge. This looks like they're. Oh, just by the address, this seems like this didn't happen at any residence. This happened at a store, allegedly.
Right.
But yes, if I'm looking at the address and getting that way, one would lead me to assume that they would live on the same street near each other on the same block. But
look on the second page. Look on the second page of the investigation report. On the second paragraph, on August 7th, the writer presented Ms. Tyler a single photo of Mr. Griffin due to knowing him for 2 months and him being her neighbor.
I see that. I apologize, Judge. That's correct. And well, I'm not saying it's correct, but it's correct that it's in the report.
And it doesn't appear to be any other relationship outside of them being neighbors.
Yeah, I don't see any domestic dynamic between the two.
And I apologize if it's already been asked and answered. Is he working?
Yes, Your Honor. He's at Package Liquor.
Okay, you did say that. Okay, since they've only been neighbors for 2 months, there doesn't seem to be an extended issue here with the parties. It sounds like this, at best, or at worst, is an isolated incident. So I'm going to give him a $10,000 personal bond, no contact with the complaining witness, nor her address. And you're not possessing any handguns, firearms, or other dangerous weapons. Next court date. Probable cause, August 19th. Preliminary examination, August 26th. In front of Judge Giles. Have a good day.
Thank you, Your Honor.
Say your name. Robert Fields.
This is case number 240-587-4101. People said Michigan versus Robert Fields. Mr. Rod, your appearance.
Right. PA 3665 on behalf of Mr. Robert Fields. We waive the reading. Mr. Fields stands mute. He's been advised of his rights.
Coroner, not guilty plea on behalf of Mr. Fields. What is your bond request?
Personal judge, no prior CCW case.
All right, given the nature of the offense, like criminal history, ties, community, $5,000 personal bond, sir. While this case is pending, you're not to possess any handguns, firearms, other dangerous weapons. Is that clear, sir?
Yes, sir.
Probable cause, August 19th in front of Judge Kevin Robbins. Preliminary examination, August 26th in front of Judge Jefferson. Have a good day, sir.
Thank you, Your Honor.
I'm full name. Renee Daryll.
Calling case number 240-587-4301. Peterson, Michigan versus Renard Rogers. Appearance, please.
Rod and Rod, PA 3665 on behalf of Mr. Renard Rogers. We waive the reading. Mr. Rogers stands mute. He's been advised of his rights.
Court a not guilty plea on behalf of Mr. Rogers. What is your bond request, Mr. Rod?
Judge, I'm asking for personal, non-assaultive case here. There's only one prior. It's serious, but it's from 2001. He's got a good job. He's been at 21st Century Demolition since 2005. Falls within the guidelines, has stable residence and no capious history. For all those reasons, I'm asking for personal bond and no firearms.
Where does he work?
He works at 21st Century Demolition since 2005.
And what does he do there?
I believe he does demolition, Your Honor. Demolition work.
Can you be more specific? What type of demolition?
Mr. Rogers, go ahead and can you tell the magistrate a little bit more about what your job entails?
We do like interior demo, like knock down walls, ceilings, and stuff like that.
Interior demolition.
Yeah, we do that too. Yeah.
Okay. Mr. Mariah wants to be like Captain Obvious today. He does demolition work. Works for a demolition company. What does he do? He does demolition work.
There's not too many types of demolition, you know.
There are several types of demolition.
Yeah.
Am I right? Am I right, Mr. Rogers?
Yeah.
Thank you.
He's got to say yes. Imagine he says no.
I could be wrong. All right, $20,000 personal bond, Mr. Rogers. While this case is pending, you're not possessing any handguns, firearms, other dangerous weapons. Probable cause, August 19th in front of Judge Giles. Preliminary examination, August 26th in front of Judge Giles. Have a good day.
Thank you, Your Honor.
What's What's your name, sir?
Delquan Watson.
Mr. Watson, I presume?
Delquan Watson.
Calling case number 240-587-4401. Pearson Minsky versus Delquan Watson. What is your bond appearance, please?
Ryan Marad, PA 3665. On behalf of Mr. Delquan Watson, we waive reading. Mr. Watson stands mute. He's been advised of his rights.
Forward a not guilty plea on behalf of your client. I assume you are asking for a personal bond?
I am, Your Honor.
Doesn't have any criminal history. $15,000 personal bond, sir. While his case is pending, you're not possessing any handguns, firearms, or other dangerous weapons. Is that clear?
Yes, sir.
Give me one moment, please. All right, Mr. Watson. Probable cause, August 19th, preliminary examination, August 26th, both in front of Judge Sabrina.
Thank you.
Okay.
Have a good day.
Thank you. All right, you too. Thank you.
Last say your name. Say it one more time. Anthony Brown.
Anthony Brown. Anybody call you J. Anthony Brown?
No, sir.
Okay. Calling case number 240-587-4501. Pearson Minsky versus Anthony Brown. Appearances, please.
Ryan Marad, PA 3665. On behalf of Mr. Anthony Brown, we waive the reading. Mr. Brown stands mute. He's been advised of his rights.
Forward a not guilty plea on behalf of your client. What's your bond argument, Mr. Rob?
Judge, on behalf of Mr. Brown, I'd indicate that he has no felony history. I think the only criminal history he had was a misdemeanor from 20 years ago. He is 45 years old, a life resident here in the state. He has 6 children in the community. He is taking a lot of medicine, Judge, for high blood pressure and heart issues. He indicates he's not received them. He's not employed at this time, Judge. He is applying for disability. I did read through the allegations in this investigator's report. It doesn't seem that there's any sort of escalation or that there's an ongoing thing. It seems that this is isolated. I think personal bond with no contact would be sufficient here. I'd ask the court for that. And a GPS tether if you absolutely must, but I'm pretty confident that Mr. Brown will be returning to court and avoiding this complaining witness.
Is he an alternative place to stay?
Yes, he's going to stay with friends and family while the case is pending. Hey, Judge.
Hold on one moment.
It's okay.
Contact while this case. $20,000 personal bond. No contact while this case is pending. You're not possessing handguns, firearms, other dangerous weapons. No contact with the complaining witness. That means just that. No contact. No phone calls, text messages, emails, having let us know through third parties on social media. No contact. We can't go back to the Pearson address. GPS tether, 9 p.m. to 6 a.m. curfew. One moment for your court dates. Probable cause, August 19th, preliminary examination, August 26th, both in front of Judge Jefferson. Have a good day.
Thank you.
Like I say, full name. Danell, Gunter.
Case number 240-587-4601, Pearson, Michigan versus Danell Gunter. Appearances, please.
Ride Morality 83665 on behalf of Mr. Danell Gunter. We waive the reading. Mr. Gunter stands mute. He's been advised of his rights.
Coroner, not good to plea on behalf of Mr. Gunter. What is your bond argument, Mr. Rod?
Your Honor, I would argue that Mr. Gunter is 42 years old. He's a life resident here in the state. He's gainfully employed at Amazon. He's been driving there for a year now. He's earned his GED. He lives with his son, and he has 4 other children, 4 children total. He understands to have no contact with the complaining witness whatsoever. It looks like there is a separate residences claimed in the investigator's report. For those reasons, I'd ask the court to consider personal bond.
Mr. Gunter, how close do you live near Miss Jackson?
We stay 3 blocks away from each other.
How many children do you have in common with her?
Just one, a daughter.
Do you work, sir?
I'm a driver for Amazon DSP. The address is 1200.
What are your work hours?
Sunday through Wednesday, 12 p.m. to 9 p.m. And then I have a Saturday mandatory chime in. So 9 times out of 10, I work Saturdays too. And I also have a part-time job also, where I'm a cook Saturday and Sunday at Poetry and Punchlines on Northwest Highway in Southfield, Michigan.
I asked you what your work hours were.
Oh, I'm sorry. 12
p.m. to 9 p.m., Judge.
To 9 p.m. I'm sorry.
What now?
12 p.m. to 9 p.m. Sunday through Monday, 12 p.m. to 9 p.m.
I got you. So a 10 p.m. to 6 a.m. curfew will help you get to all your jobs. Is that correct?
10 p.m. to 6. Yes, that's perfect.
All right, $20,000 personal bond. Given that you live blocks from each other and it seems to be an escalating situation, I'm going to fit you with a GPS tether. You're not possessing any handguns, firearms, or other dangerous weapons. No contact with Tana Jackson. You cannot go to the 7700 long address. Oh, Claiborne. I'm sorry. My mistake. And you'll be fitted with a GPS tether, 10 p.m. to 6 a.m. curfew, so allow you to go to all of your 3 or 4 jobs, how many jobs you may have.
Thank you, Your Honor.
Like I said, no contact. Probable cause, August 19th, preliminary examination, August 26th, both in front of Judge Giles. Have a good day.
Judge, with the court, would the court consider argument as to the tether? I'm reading this. I'm just kind of surprised how we get charged. It looks like the allegations took place outside of
Mr. Murad, what is anything additional new that you haven't stated before that you want to address the court with?
Well, Judge, yes. The only new information that I want to add here is that it looks like his home was attacked and he was outside of his home when this alleged incident took place. So I know
I read that. I read that, and I said this is like arguably a back and forth. And given the fact that they live, and I was wondering how they could be so quickly, and he indicated that they live 3 blocks apart. And so that's why, given the proximity, that's why I want to tether.
Understood. I apologize, Your Honor. Nothing further.
I don't have to apologize for anything. Okay.
All right.
You asked for clarification? I gave you clarification.
Thank you, Judge.
Give me like 30 seconds. Let me to the female side.
No Brian Mosby?
No Brian Mosby.
Okay.
Thank you, sir.
No problem. Here you go, Madam Clerk.
Yeah. And 32 go. Total. Okay. Gotcha.
What's your name, ma'am?
Kavana Williams.
All right. This is case number 240-587-3901. Pearson, Michigan versus Kavana Williams. Appearances, please.
Ryan Murad, PA 3665, on behalf of Ms. Kavana Williams. Kavana Williams, we waive the formal reading. Ms. Williams stands mute. She's been advised of her rights.
All right, court, on not guilty plea on behalf of your client. What is your bond argument?
So she's 18 years old. I don't see any convictions. She's has a stable residence with her father. Non-assaultive case. I'd ask the court for personal bond.
$20,000 personal bond. No contact with Thomas Jarrett while his case is pending. Probable cause August 19th, preliminary examination August 26th, both in front of Judge Sabrina. Step aside, please.
Step out. Okay. I got you. Yes, ma'am. Say your full name.
Jandra Watts.
In relation to Rolanda Watts?
Talking to you.
Talking to you?
No, I ain't talking to you.
No, I'm sorry. I didn't know you were talking to me.
You think I was talking to him?
I'm sorry.
All right, case number 240-582-0801, Pearson, Michigan versus Jandra Watts. Appearances, please.
PA3665 on behalf of Mr. Jandra Watts. We waive the reading. Ms. Watts stands mute. She's been advised of her rights.
All right, court, a not guilty plea on behalf of Ms. Watts. What is your bond argument, Mr. Rod?
Judge, this looks like a no injuries FA allegation. She has a no felony history, no assaultive history. She has a stable residence with her boyfriend and her 3 children. She's gainfully employed as a home health aide through the state of Michigan. She's been there 5 years. She works 7 days a week, 8 hours a day. I don't think that these parties live together. She understands to have no contact. I'd ask for personal bond. Looks like this is from 2 years ago too.
$10,000 personal bond. No contact with Ms. Trice. No contact means just that. And no contact with the Joy Road address where this incident allegedly occurred. You're also not to possess any handguns, firearms, or other dangerous weapons. Probable cause August 19th, preliminary examination August 26th, both in front of Judge Jefferson. Step aside, please.
Thank you, Your Honor.
Full name. Full name.
Mercedes Roberson.
Case number 240-4577801, People City, Michigan versus Mercedes Roberson. Appearance, please.
Ryan Marad, PA3665 on behalf of Ms. Mercedes Roberson. We waive the formal reading. Ms. Roberson stands mute. She's been advised of her rights.
Forward a not guilty plea on behalf of Ms. Roberson. What is your bond recommendation?
Your Honor, I would argue that Ms. Roberson is 28 years old. She's a life resident here in the state. She has no assaultive criminal history, no felony criminal history. She's not on probation or parole, no matters pending. She's gainfully employed as a production worker at Hilex. She's been there since April. She works Monday through Friday, 2 p.m. to 10 a.m. Judge, she understands to have no contact with the complaining witness. I would ask the court to consider a personal bond in this case.
Does she have an alternative place to stay?
I just called and my best friend said I can stay with her.
Okay. $10,000 personal bond. While this case is pending, ma'am, you have not to have any contact with Wanda Faye Moore nor Jessian Roberson. No contact means just that. No phone calls, emails, text messages, letters, handwritten letters or notes through third party through social media. You have to go back to the Monert address where this incident allegedly occurred. Pre-trial, August 23rd. Let me finish. Pre-trial, August 23rd in front of Judge Garrett. What is your question?
So my kids have to get enrolled in school.
Where's their father?
His father is incarcerated. He has life. I'm my only kid's parent out here. Like, my kids don't have nobody else. I'm their only parent. So I have a 7-month-old, I have a 3-year-old, a 4-year-old, a 9-year-old.
With respect to your other kids, that's not an issue with the case. You can have contact with them and you get them enrolled in school. But the child that's in question here, you can't have any contact with.
Okay, so I can still go and enroll them in school.
The children that are not an issue in this case, you can enroll them in school. You can have contact with them.
Okay, but you're supposed to learn Jason in school. That's what I was just trying to get an understanding of.
You cannot have any contact or the grandmother, somebody else has to enroll her in school.
Okay.
Have a good day.
Thank you, Your Honor.
Give me 2 seconds, I gotta get the other lady. Thank you.
Okay. $3701. Okay, what's your name, ma'am?
Trista, Billingsley.
All right, calling case number 240-587-3701. Houston, Michigan versus Trista Billingsley. Appearances, please.
Right, Marad, PA3665. On behalf of Miss Trista Billingsley, we waive the formal reading. Miss Billingsley stands mute. She's been advised of her rights.
Forward a not guilty plea on behalf of your client. What is your bond argument, Ms. Marad? Why should I not remand? Why should I not remand Ms. Billingsley?
A whole bunch of reasons, Your Honor. For starters, she's 37 years old and has no prior criminal history, no criminal convictions, no pending matters, no history of any probation or parole, no substance abuse history, to my knowledge, and no mental health history. I would indicate that she's gainfully employed she's scheduled to start a job at Fixin' Soul Food on August 12th. She was just hired in, and she's living with her mother, her siblings, and 2 of her children, ages 12 and 5. Now, when I read this investigator's report, Your Honor, I think the most emphasis is going to be placed on the statement of the grandmother that's contained towards the back of the report that talks about some sort of domestic dispute where the complainant, the decedent, had been indulging in alcohol use and committing an act of domestic violence against Miss Billingsley. I don't know how many acts of domestic violence have been committed against Miss Billingsley, but it appears that it's alleged that she had armed herself and that the decedent had tried to take that firearm, and there was a physical struggle over that firearm after and during the commission of his act of domestic violence. And it's alleged that further, this firearm goes off. For those reasons, I think there is a clear-cut case of self-defense in this particular case. And there are other things that don't necessarily point in her favor, but she is the person who attempted to take him to the hospital as well. I don't think that shows a general danger to the community. I think this is an isolated allegation where somebody who was a victim of domestic violence had allegedly armed themselves and there was a struggle over this firearm. Now, I don't think she's going to be a danger to anybody. I think that you can confine her to her mother's home where she's going to be. For the last 37 years, she's had no issues, ever. Not even a missed court date. So for those reasons, I'm asking you not to remand. I'd actually hope that you consider a reasonable bond, if not a personal with confinement. It's just a charge on its face that makes everything so serious. But when we look at her action, when it comes to bond, this doesn't scream that she's a danger to the community or a flight risk. This screams that she was a victim of domestic violence, and there's allegedly a struggle over a firearm. So that's my reasoning, Your Honor. I hope the court hears me on this, and I'd ask for confinement bond with GPS tether.
He was shot in the head.
That is the allegation, Your Honor, and it seems that there was a struggle over that firearm. I'm not sure where that firearm was pointed during the struggle.
Okay, let me read this part for you on the last page. Miss Billingsley stated, Miss Deborah Billingsley stated that Miss Trista Billingsley told her that she and the decedent were cleaning up the house. Trista was cleaning upstairs and the decedent was cleaning downstairs. After they finished cleaning, Trista told her that the decedent went to the store, brought back a bottle of alcohol, maybe tequila. Trista and the decedent were drinking in the dining and kitchen room. Table, strike that, when they started verbally arguing. Ms. Deborah Billingsley stated that her daughter told her that she, Trista, did not remember what the argument was about, but that the argument would eventually become physical when the decedent started pushing fingers into her side of her head. At this time, Trista tried to walk away, but the decedent followed her. Ms. Deborah Billingsley stated that Trista told her that she grabbed the gun from the linen closet and the decedent asked her if she was going to shoot him. Ms. Deborah Billingsley stated that Trista said to her that she told the decedent to leave when the decedent grabbed the gun that was in Trista's hand. They both began to tussle over the weapon, and the gun went off, and the decedent fell backward. It was at this time Trista knew that the decedent was shot, and Trista began to panic. Is that what you're referring to, Ms. Marad?
That's exactly what I was referring to, Your Honor. Somebody gets a chance, it should be Miss Billingsley, Your Honor. I believe she's a victim.
So you're claiming she got the gun in self-defense?
Absolutely, and she was followed during being abused by somebody who was under the influence. I don't know how many times it's happened.
Pushing fingers into the side of her head?
Your Honor, I'm not going to minimize any domestic issue. I don't know how that played out, but pushing fingers coupled with following you when you're trying to walk away, that shows me a pattern. That shows you can't do that, especially if you're under the influence. I don't know how many times he's done it, allegedly.
And this is her children's father?
So.
And then they tried to convey him to the hospital.
She did.
There's allegations that he went to the store to get any alcohol. There's nothing to indicate from the report that either of them have been drinking or intoxicated.
I believe there's an indication that he was indulging in alcohol. Let me see exactly where I can find it. Yes, it says on the.
What page?
It's under, I don't know exactly what page, but it is where Deborah Billingsley's statement starts. At the bottom of that page, it's the following page. It would be in the.
That's what I read. He went to the store and brought back a bottle of alcohol, but it doesn't indicate that they were drinking.
Trista and the decedent were drinking at the kitchen table when they started verbally arguing.
Drinking what?
You're right. You're right. But I mean, I think the way I read it is bringing back alcohol and then drinking. I would only assume drinking
That's
alcohol. But
that's a leap there that I'm not prepared to make.
I understand. I understand. I don't think that changes my argument, but I do understand your point.
It does not. It does not. I was just bringing out the fact that there is nothing in here to confirm that they both have been drinking alcohol. Yes, he brought back some alcohol. They have been drinking, but we don't know what. And as to your point, even if assuming it's alcohol, they both are drinking it.
So it actually helps my argument. Your deduction actually helps my argument, Your Honor. So I agree with you.
All right. I'm going to remand her. I think the evidence, presumption of guilt here is quite apparent to me under MCR 6.106F. I don't see a viable self-defense claim here. If anything, it looks like the decedent was trying to defend himself.
I follow
once the deadly weapon was brought out, and then apparently,
by grabbing it, Judge, instead of walking away like she told him to.
She could have walked away and not pulled a gun out on him.
She tried to walk away.
Look where we are. Look where we are today. I'm going to remand her into custody, Wayne County. I'm going to remand her into custody of Wayne County Jail while this case is pending. Probable cause, August 19th in front of Judge King. Preliminary examination, August 26th, 1:35 p.m. in front of Judge King. Have a good day, ma'am.
Step up, ma'am.
That's it?
That's it, sir. Thank you.
All right, see everybody tomorrow.
See you guys.
I couldn't find where I was. I have so many laptops on here that I was like, I've got Vicky McCallum, Vicky Mac 2, Pivot. The way I said that sounded like pervert. Vaughn, was that a swear? I'm just looking at I don't want to play that one because I'm busy working on that one. Give me 1 minute to find my things. I couldn't find where it was. Oh! So now there's me and me double. I don't think we've watched this one. I don't think we've ever watched this court. Hopefully it's not boring.
Competency eval and Mr. Tract that I sent over.
I probably got it right now. What I'm okay. All right. Something we normally have those together and getting them each of 3 cases. I'm doing is
that I sent over. Just wanted to make sure that you had gotten. Hope you're on mute. I just wanted to make sure that you had gotten the competency eval and Mr. Tract that I sent over.
I probably got it right now. What I'm doing is that the judge has asked for a PC statement on each of 3 cases.
Okay.
So I am putting those together and getting them filed, and I appreciate why she wants them. It's just not something we normally have ready.
Right. Okay, yeah, no worries. I can upload the dismissal order for you on that one then. It was just, he was just found not competent a couple days ago.
Okay. All right. Thank you.
Thanks.
Bye.
I'm not able to hear anything, Judge, if you were just speaking.
I didn't hear anything either.
All right, can you hear me now?
Yes.
Yes.
Okay, all right. Good morning, everyone. It is August 9th, and this is our Nisqually in custody calendar. I'm Pro Tem Danielle Havens, and I'll be hearing your case today. Who do we have with us from Nisqually?
Sabrina Holloway.
Let me see. Brianna Holloway Factory. Okay, I'm sorry, Sabrina?
Yes.
Okay. So this is number 1 on our calendar, and it's case number 24L001337, the City of Lakewood versus Ms. Holloway. Can you please state your full name and date of birth for the record?
Sabrina Holloway Factory, 12/29/93.
All right, thank you very much. Ms. Factory, you've been charged, or Holloway Factory, I beg your pardon. You've been charged by way of complaint with 1 count of theft in the 3rd degree. This was alleged to have occurred in the city of Lakewood on August 5th, 2024. Theft in the 3rd degree is a gross misdemeanor. That means it's punishable by up to 364 days in jail and up to a $5,000 fine. I've had an opportunity to review the statement on probable cause, and I do find that it's been established for purposes of this hearing. I'll ask your attorney to please acknowledge receipt of the complaint and enter a plea on your behalf.
Thank you, Your Honor. Amelia Hickok for the record. We would acknowledge receipt of the complaint, waive a formal reading, ask the court to enter a plea of not guilty on her behalf. She is not currently bringing in any income, so I would ask the court to directly appoint my office. We did go over her rights as a criminal defendant, and she has no questions.
All right. Well, thank you very much. So I will definitely appoint Ms. Horwath's law office to work with you on your case. City, what are you asking as conditions of release?
Your Honor, the city is asking for law-abiding behavior, no similar incidents, and stay away from the Target store in the city of Lakewood. As she's probably aware, she's been trespassed from that location at this point. We are not seeking any kind of bail to be posted. In reviewing her record, it looks like she doesn't have any prior warrants or any active ones anyway. So city would be accepting just her law-abiding behavior and promise to return.
All right, excellent. Thank you very much. Ms. Hickok, do you have, or excuse me, yes, Ms. Hickok, do you have any objection with those conditions of release?
No objection, Your Honor. Thank you.
All right. So Ms. Holloway Factory, this is a good opportunity for you to think about what's going on here and what you want your life to look like, because this behavior that is alleged is concerning, and the city is being very gracious in not asking for bail here, okay? Yeah. So I am going to set a new out of custody pretrial date for you, and that is going to be on the 24th of September.
Okay.
Oh, no, I'm sorry. I'm gonna do it on the 5th of September at 2 p.m.
Okay.
And that's going to be in person at the Lakewood Municipal Court.
Okay.
Your presence is required, and you must be here on time, because if you're not here on time, you could be required to reset your hearing, and that could cause some problems for you, okay? So your new commencement date is today, August 9th. That means that the city will have through November 7th of 2024 to bring your case to trial. I am appointing Horwath Law to work with you on your case, and their contact information is on this court order, and it's your responsibility to contact them and set up an appointment. The conditions of your PR release are that you appear timely for any and all scheduled court hearings, have no new criminal law violations, keep your address updated with the court and Department of Licensing at all times, and use only your true legal name and date of birth. You are not to go on the property of or have any contact with Target. Do you have any question about these conditions?
No.
All right, so I am releasing you on your promise to appear, and we will see you back here, as I said, on September 5th, 2024 at 2 o'clock in the afternoon in person at the Lakewood Municipal Court. Thank you for being here, and I wish you good luck with your case.
Thank you.
Gesundheit. All right, we're going to get you a copy of your paperwork, but you're free to leave the hearing now, ma'am.
Thank you.
Thank you. Hi, good morning. What's your name?
Sabrina.
Thank you. Give me one moment, ma'am. This is number 14 on our calendar. It's case number 23L000367, the City of Lakewood versus Sabrina Marie Upshaw. Welcome, Ms. Upshaw. I'm Pro Tem Danielle Havens, hearing your case today. And we are here on an SOC final disposition. City, what should we know about this?
Well, Your Honor, as far as what the allegations are, and I apologize, we did try to submit something to you on this. We were probably not very timely.
This is an SOC. I'm sorry, I don't mean to cut you off in terms of, and I do have additional information for the court on what's going on in terms of that SOC.
Okay, yes, so it is an SOC final disposition. All right, I'm sorry, Ms. Hickok, go ahead.
That's okay. So yes, Your Honor, Ms. Upshaw failed to appear for her final review hearing. She had entered into this one-year SOC back on April 11th of 2023, was ordered to have law-abiding behavior and complete a firearms safety course. She indicates to me that she completed it shortly after that court hearing. I see that's consistent with the docket entry. She's called in on the 17th of May in 2023, asking if she needed to file it with the court. She indicates to me that she did complete it, but I guess that proof never made its way to the court. So I'm asking that we release her and that we set an out of custody review hearing so that she can get proof of that turned in. The only other outstanding issue I see is a pending driving while license suspended third degree. There's no resolution on that yet, so obviously we'll keep an eye on that, but I'm asking that we set an out of custody review. She's had a lot going on in her life. Your Honor can probably see that she's been the victim in a number of serious assault cases in the last couple of years. So she's doing her best to make sure that she's complies with the court's obligations here.
All right. Thank you very much. City, what's your position?
My position is I'm really glad that you called on defense because I was looking at the wrong case. We are in agreement that this matter should be continued, and I've signed off on that.
All right. Thank you. So, Ms. Upshaw, I am so sorry that you've been dealing with so much over the last couple of years, and I hope that you are taking very good care of you and that you are finding supports and protections within the community. There are a lot of advocacy groups that can help you and encourage you and guide you through keeping yourself safe. And I really hope you're taking advantage of those. I'm sure that Ms. Hickok could let you know of some if you don't already have an advocate that you're working with. So we'll set this for a review hearing. Are we thinking 60 days out?
Yes, Your Honor. The only reason I didn't put in a date is there's an affidavit on Judge Mansfield, and I couldn't figure out when the next conflict review calendar was.
I don't know that there is a conflict review, so we'll just set it on one of the conflict calendars. Okay. And that will be the October conflict calendar is, I'm sorry? Okay, 10:15 at 2 p.m. And your presence will be required in person here at the courthouse for that date. You are being released from custody, and there's no objection from the city. I will grant the motion to continue, and we'll have you abide by all previously imposed conditions. I think that we also need to do a pre-release commitment as well. Do you think, or no? I mean, you're the Nisqually expert. There are a lot of places. Okay, all right, good. So as long as it says then defendant to submit proof of firearm safety course, release from custody, and reset to review date, that's sufficient, I guess. Hold
Your
on.
Honor, there's a box. Yep, there's a box at the bottom that says
Okay. All right. Defendant is released on personal recognizance. Okay, thank you. I hit save on that. And I'm sorry, everybody else is going to have to re-sign because I made a change.
I've signed that, Your Honor. Thank you.
Okay. All right. So we will see you back here on October 15th at 2 p.m. And we'll look forward to having that information about your class then, okay?
Thank you.
All right, I wish you very good luck moving forward. Hi, what's your name, sir?
Brian McQuain.
I'm sorry?
Brian McQuain.
All right. Hi, Mr. McQuain. My name's Danielle Havens, and I am the pro tem judge hearing your case today. So we are here on number 3 on the calendar, case number 24L000853, the City of Lakewood versus Brian Vance McQuain. Mr. McQuain, you are charged by way of complaint with 1 count of knowing possession of a controlled substance. This was alleged to have occurred on May 19th, 2024 in the City of Lakewood. This is a gross misdemeanor punishable by up to 180 days in jail and up to $1,000 fine. I had an opportunity to review the statement on probable cause, and I do find that it's been established for purposes of this hearing. I will ask your attorney to please acknowledge receipt of the complaint and enter a plea on your behalf.
Thank you, Your Honor. We will acknowledge receipt of the complaint, ask the court to enter a plea of not guilty on his behalf. He is not currently housed and doesn't have income, so we would ask for direct appointment to my office.
All right, thank you. I will directly appoint the Horwath Law offices to work with you on your case. I also want to make known to you, sir, that right across the street from the Pierce County Jail, there is a community resource center, and that would be a very good place to go to discuss housing. You may be able to get something started there so that you are able to be housed, and I encourage you to do that. City, what are you seeking as conditions of release?
Your Honor, in this case, we're asking for $1,000 cash or bond. If you look at Mr. McQuain's record, you'll see that he has active warrants out of both Fife and Puyallup. He doesn't have a particularly violent history or anything like that, but we just need some reminder to him to show up for court.
Okay, thank you. Ms. Hickok.
Thank you, Your Honor. I'm going to ask the court to consider releasing my client today. As the city noted, he does not have any violent history. He was summoned in for his arraignment, obviously did not receive that notice because he's unhoused. He does not have a good mailing address right now. But in speaking with him, he indicates to me that he is able to make it to court, would like the opportunity to appear out of custody. So I would ask that the court give him that one opportunity to appear out of custody, given he was originally summoned in for arraignment.
Well, one of the things that makes this challenging for me, Mr. McQuain, is the fact that you have 4 open warrants. You have a warrant that is here from December of 2018 in Grays Harbor District Court. You have a warrant from the Roy Municipal Court from March of 2021. And then you have 2 warrants from this year, one in Fife and one in Puyallup. And one of the things that I know is that each of these hearings, you've been told that you have to quash those warrants, and yet they remain open. And I find that concerning. So hold on one moment while I look at some of this. Okay, so yeah, on your Puyallup case, there's already been a finding of guilt made on that, and you then failed to appear for a compliance review hearing because there was a new law violation, the ignition interlock violation. And then with regard to the Fife warrant. Okay, so you did not appear for your arraignment in Fife. So I do find this concerning because what's really important for us here, Mr. McQuain, is that we're able to move these cases along and have them resolved. So I understand that any amount of bail is probably more than you are going to be able to deal with, but I am going to impose bail in the amount of $500 cash or bond. I'm going to put this on the Nisqually calendar for next week. That'll be August 16th at 11 a.m. And it is my hope that you will be able to reach out to these other courts and figure out how you're going to quash those bail amounts there as well. You have a right to a speedy trial that begins today. If you remain in custody, that will expire on October 8th. If you are out of custody, it would expire on November 7th. As indicated, I've appointed the Horwath Law Group to represent you. The conditions of your release, if you post bail, are that you appear timely for any and all scheduled court hearings, have no new criminal law violations, keep your address updated with the court, and use only your true legal name and date of birth. You are not to go on the property of or have contact with the 7-Eleven. And was there any other condition that the city was seeking? I'm sorry.
No, Your Honor, that's satisfactory to the city.
All right, thank you. And so probable cause has been established today, and I am imposing that $500 cash or bond. So I wish you good luck, sir, and I'm going to ask our clerk to please print your case history so that you know where you have those warrants and you can look to getting them quashed over the next week, okay?
So how about look at getting out of jail?
I beg your pardon, sir?
So how about look at getting out of jail?
Yeah, you're not getting out of jail today, sir. Oh, yes, and I will set an out of custody date. I'm sorry, you'll have to sign again because I didn't put it on here. Oh, Ms. Hickok, yeah, he hadn't signed. So the out of custody date, should he post, will be September 5th. Okay, so I'll save that and then I'll need you to sign again, Ms. Hickok. My apologies.
And that should be there, Your Honor, my signature.
Thank you. Good morning, sir. What's your name?
I'm Joseph Allen Sharp II.
All right, give me just one moment, sir. These are numbers 10, 11, 12, and 13 on our calendar. Cause numbers 24L001203, 24L001263, 24L001268, and 24L001343. This was a competency matter, and we are then here for arraignment on the case number ending in 1343. And I do have a recommended service plan that has arrived here. Ms. Hickok, would you like to make a record?
Yes, Your Honor. There was actually a competency evaluation that was completed. That was done on the 2nd of August. That was submitted to the court. Both myself and the city have reviewed that based on their finding of his inability to proceed. Blue City is moving to dismiss without prejudice and requesting the 72-hour DCR hold, which I have no objection to, and that should all be filled out in the order.
All right, thank you. And City, are you in full agreement with that?
I am.
All right, thank you very much. So, Mr. Tract, this case is going to be dismissed without prejudice at this time. What that means is that it could ultimately be refiled. But for now, it's being dismissed. The report of the evaluator found that you are not able to assist in your defense or to understand everything that's going on here. And that's very essential for us in being able to process cases. So you don't have a history of violent acts, and with your inability to either understand or assist, we are dismissing this case without prejudice at this time. We are going to detain you so that a DCR a designated crisis responder will be able to come and meet with you and try to employ a service plan. I got to read the recommended services plan, and it seems quite optimistic to me. I think that there are some things that could really assist you, and you are eligible to participate in some of these programs. So I am going to detain you until 11 a.m. on August 14th, 2024, so that the crisis responders can come and talk with you. I wish you very good luck as you move forward, sir, okay?
Okay.
All right, thanks for being here. We'll make sure that you get your paperwork and you are excused from this hearing.
Thank you.
All right, good luck to you.
Thank you.
Thank you. Okay. I'm sorry, you said Mr. Mraz? Okay. So number 4 on our calendar, the first pretrial hearing on 24L001334, City of Lakewood versus Jose Ignacio Mraz. We have received information that Mr. Mraz returned to his unit and does not wish to participate in court today. Had you spoken with him yet, Ms. Hickok?
Yes, Your Honor. I can make a 3-4 appearance for him. We had a plan moving forward. I've noted, I've drawn up a pretrial conference form and noted there are no changes in conditions of release, set it for trial readiness, and also included a backup out of custody date should he post bail.
Okay, thank you so much. So we have a motion hearing date requested for August 20th, 24 at 1 p.m. here in the courthouse, with a readiness hearing on August 16th, 2024 at 11 a.m. That will occur through the Nisqually Jail, and his presence will be required in person for trial. Let's see. So trial would be then the week of what?
Your Honor, it's the next week after, so the week of the 19th?
19, yes. So week of 18, 19, 20, okay.
Yes.
Yeah. Oh, no. Okay. So discovery is complete and a 3-5 hearing is requested. A hearing is being requested to address the admissibility of the 911 tape. There are no 3-6 issues. Witnesses on behalf of the city are listed in the police report and other discovery. Witnesses on behalf of the defense are due no later than 2 weeks prior to the readiness hearing. There are no affirmative defenses called at this time. Speedy trial expires on October 5th of 2024. There are no changes to conditions of release, and there's a backup out of custody date of August 15th at 1 p.m. at Lakewood Municipal Court. Any objection, City?
No objection, Your Honor.
All right, thank you so much. I will grant that motion to continue in order that he continue to abide by all previously imposed conditions, and I have signed off on that court order. Okay.
And Your Honor, there are two individuals that are not, let's see here, not going to be brought. So Mr. Terrence Ray.
Okay.
I've been informed by the jail. So this is new to me. I did not know that the Nisqually jail had contracted with Tacoma Municipal Court, but they have in the last couple of weeks. So he's been transported to the courthouse, and they don't expect that he'll be back in time for court. He's handling his Tacoma case. So we'll probably just have to bump it over to Monday.
Okay, hold on one moment. Heather just indicated that they told her he's on his way back. They didn't give her an ETA, but did it seem to you that they were implying that he would be back in time for his hearing? All right, she's going to check in there.
And then,
oh, he just got back. He'll be available within the next 5 minutes.
Perfect. Then the other matter I have is Michelle LaRoque. I tried to talk to her before court. That's cause number 24L1360. She, I've uploaded a competency evaluation for her. I don't think she's in a good state to be brought to court. And I'll reserve on any sort of bail argument. I was not able to have a meaningful conversation with her.
Okay, thank you. I'll pull up her paperwork here. So with regard to Ms. LaRoque, this was a theft in the third degree and attempt assault or 2 counts of assault for. And there have been previous findings of incompetency out of other courts. You had concerns about her ability to engage in a meaningful conversation with you. A DSH evaluation by a qualified evaluator is going to be ordered at the Nisqually jail. And let's see, do we have defense attorney wishes to be notified?
We don't need to be notified, Your Honor. I have a standing agreement. We have a standing agreement with them that if the defendant asks for us to be present, we will be. Otherwise, we don't be there.
All right. So the defendant is directly appointed to Horwath Law. And we've got a new date of August 16th, 2024 at 11 a.m. on the Nisqually jail calendar. The parties stipulate that statements, admissions, or confessions made by the defendant in the court ordered evaluation are not admissible into evidence against the defendant. So I'll sign off on that.
Thank you.
And then with regard to bail, is the city requesting a bail amount?
And this is for Ms. LaRoque?
Yes.
I'm sorry. Yeah. I didn't find a lot of failures to appear on her part, despite some of the concerns with competency. And there was, obviously there was assaultive behavior involved here, but I would be willing to have her released on her own recognizance based on my read of these facts, as long as she comes back and she does what she's supposed to do. You're giving, are you looking at me? It's hard to tell with Zoom.
So if that is.
Well, the one that I was concerned about today, I looked at 3 of them, and the one was Mr. McQuain with his live warrants. But in looking at her, there is a lengthy history, but I'll take another look at it and maybe perhaps I reserve the right to revise what I was saying.
Yeah. What my concern is,
so I'm looking at it right now. She's had a couple dismissals without prejudice. She had domestic violence issues. This, to me, when I looked at her record, looked like the first time she had assaultive behavior with non-relations, which obviously those are different dynamics. And that's kind of what I was looking at here. I personally charged this, and I understand the assault, and I think the court reviewed it as well. It was in an effort to get away, which doesn't necessarily justify it, but sometimes we see people who are preying on complete strangers, and it's just outright assault for no reason. So I was giving her the benefit of the doubt.
My concern is over I'm gonna hold her in custody on $500 cash or bond.
Your Honor,
So
note
probable cause, I did review the report for probable cause. I do find that it has been established for purposes of this hearing. And I'm going to,
Sorry to interrupt, but at the end of this one, I need to say goodnight, which is in about 15-ish minutes.
let's see, I'm gonna, on the attempted theft, I'm holding her on $100. And then on each of the assaults, I am holding her on $200 cash or bond. I appreciate the city's record. I just do not feel confident in her ability to appear, and I'm worried about a change in behavior to assaultive behavior and the risk that that poses to the community. So I have signed off on the court order.
Your Honor, would just note our, in light of the city's recommendation, would just like to know that we reserve our bail argument in hopes that we can have a conversation with her later that's more meaningful.
Yes, the docket will reflect that the defense is reserving on their bail argument.
Thank you.
All right, Mr. Ray, I presume.
Yes, Your Honor.
All right, welcome to court. Thanks for being here. I'm glad that you got back on time. Beg your pardon? On order? That is weird. Hold on one moment. Huh. I don't understand. I can see them. Give us one moment, Mr. Ray. My apologies. It says judge has signed, and for me it says, can you hit? Okay. Yeah, I'm looking at it right now and it has my bail amounts on it. It's under the theft 3 attempt. PC is established, $100 bail. Assault 4th degree, PC is established, $200 bail. Okay, all right, we'll come back to that. Thank you. All right. Okay, just one moment, Mr. Ray, my apologies. Okay, so these are the matters of Terrence Javon Ray. We have case numbers 22L001027, 22L001122, 23L00066, 24L001070, and 24L001214. All are the City of Lakewood versus Terrence Javon Ray. And Mr. Ray is present and represented by Ms. Hickok. Go ahead and make your appearance, Ms. Hickok.
Thank you, Your Honor. I do need a moment to speak with him, Amelia Hickok, for the record, given he was just taken back from Tacoma.
Yes, thank you. Go ahead.
Okay, and then Mr. Ray, are you able to join a breakout room, or maybe bring the officer back in so that you can join a breakout room?
Yeah.
Okay.
So are we coming back in 5?
Yeah.
Okay, that's what I'll do.
Thank you. Okay, so it's on the pretrial release commitment form. Oh, no worries. So we were looking at Mr. Track's case, and one of the case numbers had a no contact order associated with it. So I'm going to, I'm just adding an order on motion, and I'll indicate that the city is moving to recall the no contact order. Oh. Ms. Hickok. Pardon?
I think that's all we can do at this point.
Yeah, yeah. Ms. Hickok, on the tract matter, there was a no contact order on one of the case numbers. And so I'm just adding a motion to recall the no contact order.
She may be in the breakout room with her client.
I'm back
She's
now.
on, I can
Oh,
see her.
she's back, okay.
I've signed off on that, and it will need both of your signatures. Also, I added a line on the LaRoque competency order, and so it wiped both of your signatures off. And I just added that there is bail in the amount of $500 imposed on that case. So if you could both sign all of those documents.
Apologies, Your Honor. I was just finishing Mr. Ray's order. I will go back and sign that now.
Thanks so much.
Okay, and I've signed both of the LaRoque documents. And did you say Mr. Tract had something I needed to sign as well?
Yes, on Ms. Tract, there is, or Mr. Tract, I beg your pardon. On Mr. Tract, if you would please sign the order on motion to recall the no contact order.
Got it. My signature should be there now.
Thank you so much. Okay. So then we can go back onto the record on the Ray matters. I'm not going to call all the cases again. They were the last numbers that we called. So I think that is that all right with you, Heather, or do you want me to call them? Okay, it's all right with Heather, so we will leave it at that. What is our plan today on Mr. Ray's case?
So, Your Honor, Mr. Ray has a number of cases before us. He's somebody that I've worked with for a long time. He's not being held on any of our charges right now. He's only being held on his Tacoma municipal cases. Our plan today is to move the court to continue these matters. I'd like to facilitate some sort of global resolution. They're all kind of crimes of a related nature due to him being indigent and unhoused. Would love to be able to organize something with his Tacoma attorney so that he will only have to report to one court. So we did a motion to continue with a speedy trial waiver. I put in an in-custody date of week after next, since his next hearing in Tacoma is Friday of next week, and then also put in a backup out-of-custody date should he post bail on that Tacoma matter.
Well, fantastic. Thank you very much. I appreciate that you've done all of that. So, Mr. Ray, one of the things that I want you to be aware of is that right across the street from the Pierce County Courthouse, there is a resource center. It's a community resource center, and that is a place that you can go to get assistance with all of the things that you need to do. So you can look for housing there, you can find jobs there. There's a clothing bank, there are food opportunities, there are bus tickets that you can get. There there's housing opportunities, and they can help you to get involved in any of the treatment that you need to get involved with. And I've just been looking at your record, and I know that you were dealing with stuff in Pierce County District Court. And when I saw your name and saw your face, I recognized you. You've appeared before me at Pierce County District Court also. And so I know that we have come in contact with each other, and I really appreciate that Ms. Hickok is looking at the big picture here and trying to get something sorted out for you so that you can move beyond all of these challenges that you've been facing. And I know that you went to Greater Lakes, and I know that you have mental health meds. You've got a lot going on, but there are a lot of helpers in place. And what I need you to work on and try and commit to is helping the helpers help you. Okay, so that means letting people know what you've got going on and what your needs are. And that can be really hard because it involves, having to talk about things that feel scary or embarrassing or upsetting. And I know how difficult it is to feel humbled in front of other people. I've felt those feelings too. And I think probably everyone that you're looking at right now has as well. And so it's hard, sometimes I think, especially for men, to make themselves vulnerable in that way. But if you do, then you're going to be able to get the assistance that you need to deal with these challenges that you're facing. And it makes me sad when I look at a docket and half of it is taken up with one person's cases, and they're all so similar in nature, and they have so much to do with indigency. And that makes me feel like our society is failing you. But I know that right across the street from the courthouse in Tacoma, there are lots of resources, and that can be where you go to get a hand up, okay? And so I really want you to consider going there and spending the time that you need to there. So we've got a motion to continue to August 21st, and that will be at 11 a.m. And that's on our jail calendar. But if you are out of jail because you've dealt with the Tacoma Muni case, then you're going to need to come back here for an out of custody date on August 29th at 1 p.m. at the Lakewood Municipal Court. And all of the other conditions of your release remain the same. Do you know what those are?
Yes.
Okay, so law-abiding behavior, being your best self, not going to places that you are not supposed to go to, and staying in good contact with the court, okay? We've got Ms. Hickok's law firm. I'm putting their address or their contact information, on this court order. And I am going to grant the motion to continue in order that you abide by all of the previously imposed conditions. And I'm indicating that you're released on your promise to appear in our court. That doesn't change the Tacoma Muni hold, but it does deal with our court. So if you get out next week, you'll be able to come to court in person on August 29th. And just make sure that you go to that resource center, okay? All right. Well, I wish you very good luck. Thank you for being here. And I'm so glad that we got to see you and that you made it back in time.
Thank you.
All right. You take good care of yourself. See you soon.
House 2 pulled their card out. They got a tray on it.
And I think that's everybody, Your Honor.
Okay, I believe it is as well. Thank you very much, Ms. Wally.
Have a good day, everyone.
You too. And thank you, Ms. Hickok. And I'm always nervous to say your last name.
Me?
Yes. It's Watcher? It's Watcher?
Wachter. Rhymes with doctor.
Oh, Dr. Wachter. Okay, thank you so much.
You're
I
welcome.
appreciate that. Wachter. Rhymes with doctor. That was all I needed. All right, thank you.
Bye-bye.
All right,
Thank you.
have a great weekend, everyone.
You as well.
I thought she was going to be nervous to say Hickok because I'd be nervous with that one. I was going to end now, but I see there's like a bunch of people that just joined. So I'll put in another one, but I need to keep stretching my muscles and not being in front of the screen. So if you don't mind that, then I am happy to put one on. This one looks like it starts with an interpreter, which is a bit hard for the brain. But this one might not. Okay, judge starting off muted.
Can you hear me now? No?
Yeah, we can't hear you still.
I can try alt.
Yeah. Yeah, there's some degree of truth to that. All right, Ms. Hickok, can we hear you yet?
I don't know. Can you?
Yeah.
No?
No?
No. Okay.
You turned green. Yes, gentlemen at the Nisqually jail, would you please say something? Okay, we can't hear you. All right, it's an us problem. Ms. Hickok, on the last calendar, we had Mr. Davis, and the jail did not accept my order because while I checked the box that said abide by previously imposed conditions, I did not write in there is no change to conditions. So I had to write that in, and now Mr. Carlo's signature has been removed. Would you mind signing that for us?
Yes, I will. Mm-hmm.
Oh, we can hear you now. Yay.
Oh, okay.
Great. Gentlemen in custody, would you please say hello? Okay, we still can't hear you.
Yeah, I would go grab the officer out there. Yep.
Can you hear us now?
Yes, thank you so much. All right, we are on the record. Welcome to court. It is July 12th, 2024, and this is our Nisqually in custody calendar. My name is Danielle Havens, and I am a pro tem judge today. What's your name, sir?
Jesse McGrath.
Hi, Mr. McGrath, welcome. So this is number 4 on our calendar. Calendar, cause number 24L001170. The City of Lakewood versus Jesse McGrath. Mr. McGrath, would you please state your full name and date of birth for the court?
Yes, ma'am. That'll be Jesse McGrath at 06/21/03.
All right, thank you very much, sir. So you are charged by way of complaint with 1 count of assault in the 4th degree with a domestic violence allegation. The maximum penalty for that charge is 364 days in jail and a $5,000 fine. It also could include the loss of your right to use or possess firearms. I am going to swear the prosecutor in and ask him to please establish probable cause on the record.
Correct. Did defense not get the police report to stipulate? I'm happy to do that. I just wanted to make sure that
I actually need to hear. I am not comfortable not hearing what probable cause is.
I apologize. I should have.
Oh, that's all right, Mr. Vincent. It's our first time together.
On the listed time and date, Jesse.
I need to swear you in first.
Sorry.
No problem. Do you swear or affirm that the testimony you will provide will be true and accurate under penalty of perjury and the laws of the state of Washington?
I do, yes.
Thank you. Please proceed.
On July 11th, the officer was working as a uniformed patrol officer for the City of Lakewood Police Department in a fully marked police patrol vehicle within the city limits of the City of Lakewood. At approximately 14:35 hours, he responded to the Nablus Apartments located at 12701 47th Avenue Southwest, number C1 for a DV assault. Upon arrival, he contacted Ryan Nelson Radu inside of the apartment. Ryan was upset and crying. When he calmed down, I asked her what happened. She stated that just prior to the officer's arrival, she and her boyfriend, Jesse McGrath, had been involved in an argument over a cell phone cord. During the argument, Jesse used one of his hands and struck the back of her head with a closed fist. Jesse struck her several times on the back of the head and once on the right side of her torso near one of her ribs. She also stated that Jesse had bitten her left hand. Ryan had no visible marks on the back of her head or on her hand. Ryan allowed Officer Cabry to take pictures and look at the area. Jesse had walked to a nearby store just before officers arriving.
All right. Thank you very much. I do find that probable cause has been established for purposes of this hearing, Mr. McGrath. Ms. Hickok, will you acknowledge receipt of the complaint and enter a plea on your client's behalf?
Yes, Your Honor, would acknowledge receipt of the complaint and ask the court to enter a plea of not guilty on his behalf.
All right. A plea of not guilty shall be entered. City, what are the conditions of release you seek?
Your Honor, the city defers to the court as to conditions of release. The city notes that this is the defendant's first and only matter on his DCH.
All right. Thank you very much. Ms. Hickok, do you have any suggestions on conditions of release?
Your Honor, it doesn't appear that the city's asking for a no contact order. I would also ask that the court not impose a no contact order today, as I know it sometimes happens in cases where domestic violence is alleged. I don't see any criminal history at all for my client. Was able to have a long conversation with him before court today. He's able to come to court and I have no doubts that he'll be able to do that and will have law-abiding behavior during the pendency of the case.
And I apologize to the court and Ms. Hickok. I misread the note. The city would be requesting a no contact order at this time.
Okay.
Has the city been able to make contact with the alleged victim this morning? It was something that I had planned to do, was not able to not have time to do it.
And that was my misunderstanding. I thought we had and we hadn't. So since we have not, I'm requesting the no contact order until we do have a clear communication with her.
Okay. All right, Mr. McGrath, this is the only charge that I see on your record. You don't even have a speeding ticket or anything like that. And that does mean a lot to me. So first off, I want to tell you that I'm releasing you on your promise to appear. I am not going to impose any bail. I think that's completely unwarranted because we don't have anything here in front of me that would tell me that you will not show up. I believe that you will. And I think that because to get to your age without having any criminal law violations, to me, says that you typically exercise good judgment. And it would be real bad judgment not to come back to court. So I am not imposing bail, and I'm going to have you come back for a hearing on August 13th, 2024 at 1 p.m. in our courthouse. And so that'll be in person. Yep, at the Lakewood Municipal Court. Did you screen him for public defense, Ms. Hickok?
Yes, Your Honor. He does, in speaking with him about his finances, he does some temporary sort of labor work for Labor Works. I'm asking that the court directly appoint my office, as I do think you'd qualify.
Okay, thank you. So you have a right to a speedy trial, and that right begins today. So that means if you were not to waive your right to a speedy trial at any point, that your case would need to be resolved by October 10th of 2024. I am going to appoint Ms. Hickok's office to work with you on your case. So they're called Horwath Law, and their information is on your court order, and there are directions about how you should make contact with them on your on your court order, excuse me. The conditions of your release are that you appear timely to any and all scheduled court hearings and have no new criminal law violations. You're to keep the court updated with your address and the Department of Licensing as well at all times. You're to only use your true legal name and date of birth. I am going to issue a no contact order right now. And that is only because we have not had an opportunity to speak with the alleged victim here. And I beg your pardon?
How fast can you lift that? Because that is my baby, that is my child's mother.
Okay. All right, hold on. We've got someone trying to log in.
That's okay, I can skip that question.
Yeah, what is the name of the individual? Oh, the name of the individual who's protected is Ryan Nelson Radu.
Can she be called after this?
All right. Okay, I want you to please be quiet. I'm going to invite her in and I'm going to hear from her. Please do not say anything to her and do not respond to anything that she says, okay?
Am I allowed to talk now? I'm sorry, ma'am.
Hi, I can't see you. Where are you?
Oh, I'm sorry. I'm trying to turn on my camera. Okay, wait, sorry. There we go. Are you able to see me now?
Okay. Yeah, I can see your outline. I can't really see you because you're backlit.
I'm sorry.
Oh, there we go. All right.
Hello.
Hi. What's your name, ma'am?
My name is Ryan Alexandra Nelson Radu.
Okay, welcome. We were just talking about Mr. McGrath's case.
Yeah.
What we were wondering about is if you are seeking a no contact order here.
I'm not seeking a no contact order because I truly feel like this had to do with his mental health right now. His mom passed. So I feel like he's never done this before. He's not like this. He's a great father and a great partner. It was just one incident. I feel like, you know, him being, you know, going to jail would not help. Like, it's not going to help the underlying issue. But I know he has expressed he wants to get mental help and he wants to go to speak to a counselor at Greater Lakes. And I just feel like a no contact order, you know, wouldn't do anything. You know, I love him. His son loves him. He's a great father. He helps me out.
Okay. How old is your son?
He's 8 months.
Oh, congratulations.
Yeah. Thank
That's
you.
lovely. Okay. Well, thank you very much for signing in. I really appreciate that.
You're welcome. Thank you.
Okay. So, City, what is your position on no contact order?
Is my understanding that the alleged victim is 19 years old, and the indication of possible mental health issues does give the city pause to not request a no contact order, but she did appear very articulate and understood the situation. Therefore, the city would defer to the court as to imposition.
Thank you. I appreciate that. Okay, well, I am so grateful that you were here, Ms. Nelson Radu, because I was in a position where I was going to impose a no contact order because we didn't know what you wanted. And so
yes, I got a call this morning, but she didn't like add me.
Okay, it's okay. So what I want both of you to hear is this. I am not going to impose a no contact order. But Mr. McGrath, I am going to give you a directive that you are to have no hostile contact with Ms. Nelson Radu. So when we are grieving, there is a lot going on. And grief is one of the most difficult, long-lasting journeys that we'll ever travel in this life. And it is really, really hard. And it can change how we act. It can change how we feel about things and what we do. What I need you to understand right now is that it's not going to go away, but it will evolve. Your grief will change over time. And one of the best things that you can do is find a grief support group so that you have a place where you can talk with other people about how hard it is to lose someone that you love. And another thing that you can do is when you are feeling the pressure and the tension build up, you've got to focus on your breathing. And there is a breathing technique that's called box breathing. And I'm going to put that in your court order because that's something you can Google and you can really start to help yourself with. But this has to be the end of any kind of hostile acting out, okay? So there is to be absolutely, and I'm going to put this on the order, no hostile contact with your partner. If you find yourself feeling frustrated, you need to leave and come back. And Ms. Nelson Radu, if he ever says, I am getting so frustrated, I'm going to go, you have to say that's such a good idea. You know, I love you, be safe, come home when you're calmed down. And when the two of you are talking about things where there may be some disagreement, it's really important that you sit down, preferably across a table from each other, and sit on your hands. Or if you're able to talk calmly, hold hands across the table. But do not ever act out in anger or frustration because, as you see, nothing goes well from that point on. All right, so the conditions of your release are going to be the appear for all court hearings, have no criminal law violations, keep your address updated immediately with the court and Department of Licensing, use only your true legal name and date of birth, don't have any hostile contact with Ms. Nelson Radu. And I'm going to look up videos on box breathing. Now, this is not a condition, this is a recommendation. Oops. Beg your pardon? Yes. Yes, thank you for catching that. All right. So we are going to have you, they're not conditions, they are recommendations, and those recommendations are that you look up videos on box breathing and you look into finding a grief group. And what a beautiful son you two have. All right, so probable cause has been established today. I am releasing you on your promise to appear, and we'll see you back here on August 13th, 2024 at 1 p.m. So I wish you very good luck and be careful and gentle with yourself, okay?
Thank you. Bye.
All right. We'll see you back here then. Take good care. And Ms. Hickok, that order is ready for you to sign.
Do I go out here or?
Yeah, you'll be released today and you can go home.
All right.
Okay?
So do I leave the room? That's what I was wondering. Do I need to?
Yeah, you get to leave that room and tell them we're ready for our next guest. Thank you.
Thank you, ma'am.
All right, bye-bye. Thank you, Ms. Nelson Radu. And bye, baby. Hi, what's your name, sir?
John Leroy Landers.
And Your Honor, I'll need a brief breakout. I spoke with him before court and had an update for him on an offer from the prosecutor. So if I could just have a very brief breakout room with him,
Okay.
that would be
Thank
great.
you very much.
Thank you.
You said John Leroy Landers, correct? Okay. All right, I do believe it's him, yeah. Pardon? Oh, excellent. Thank you very much. Soon tight. My brother always says what they say on Seinfeld when people sneeze, which is, "You're so good looking." I think it's hilarious. So funny. All right, they're back. All right.
And Your Honor.
Yes, so we're back on the record on excuse me, I'm sorry, I moved calendars. On the John Leroy, no. I'm sorry, which matter is this? Mr. Landers?
Mr. Landers, yes.
Okay, all right, thank you. Go ahead.
And Your Honor, the parties have reached a resolution today. Mr. Landers will be pleading guilty to one count of harassment, non-domestic violence. I have gone over statement of defendant on plea of guilty with my client. I believe he's waiving his rights intelligently and voluntarily, discussed any potential immigration consequences. I believe he's ready for any questions Your Honor may have. This agreement contemplates essentially credit for time served and no period of supervision, the file closure.
All right, thank you. I'll have you fill in that form while we chat. So, Mr. Landers, is your true and correct name John Leroy Landers?
Yes, Your Honor.
And you're 31 years old and you went through at least 8th grade in school?
Yes, Your Honor.
Okay, do you understand the elements of harassment that the city will not be required to prove because you're here saying, yep, that is exactly what I did?
It is correct. That is
Okay. So you have very important constitutional rights. When you enter a plea of guilty, you're waiving all of them. So they include your right to a speedy and public trial by jury, the right to remain silent and refuse to testify against yourself, the right at trial to hear and question any witnesses who testify against you, and to call witnesses to testify for you. You have a right to be presumed innocent unless this charge is proven beyond a reasonable doubt. But when you enter a plea of guilty, you are waiving all of those rights and your right to appeal a finding of guilt after trial. Is that your understanding and intention today, sir?
Yes, Your Honor.
All right. The maximum penalty for harassment is a year in jail or 364 days in jail and a $5,000 fine. There is a recommendation here that is agreed by the parties, so it's my intention to follow it, but I'm not required to. I could sentence you up to the maximum penalty. Were you aware of that, sir?
Your Honor.
All right. And if you are not a U.S. citizen, though I am not asking you to confirm your status here, it's simply important that you understand that a plea of guilty could be grounds for deportation or exclusion from admission to the United States. Were you aware of that, sir?
Yes, Your Honor.
And has anyone made any threats or any promises other than what's contained in this agreement in order to encourage you to do this?
No, Your Honor.
Okay, and there's a statement here in paragraph 11 that reads, on or about June 28th, 2024, in the city of Lakewood, I threatened to cause bodily injury to another, and by my conduct, I placed this person in reasonable fear that the threat would be carried out. Is that a true statement?
I wouldn't say that the threat would be carried out. I don't remember threatening anyone in the first place. But if that's what's consistent to what he said, I
Okay. Are you adopting this statement as your own today then?
not really. No.
And Your Honor, if you'd like, we can submit the police report and you can read that to determine there's a factual basis to find the plea. I'm happy to delete that and just have the prosecutor send
that would be fine. I'd be happy to do that.
Thank you. And Mr. Vincent, are you able to send that over?
Yes.
Okay. So I'm just going to check the box that says no statement made for review of the police report here.
Thank you.
And which email address should I send this to?
Machine.
Can you send it to Danell, Danielle?
Sorry, just one moment, please.
Okay.
Strong's.
So Danelle, the protem.
Okay.
At gmail.com.
Oh yeah, Liberating Industries. We marked the machine. Yeah.
Are you doing okay, Mr. Landers?
Yeah.
Okay.
DANIELLE
at Danelle, the THE protem at gmail.com.
Two 83, 10, 380, 25, 45, 357. I'll stay alive.
And while we're waiting on that, if I could just have another breakout room with Mr. Landers, just to make sure that he's tracking and everything is okay.
Okay.
Thank you.
And Madam, I have just emailed that.
Great, thank you. It still has not quite come through yet. Oh, there it is. Thanks, Brett. Mr. Vincent, beg your pardon, ma'am.
Feel free.
All right. Okay, thank you. I have had an opportunity to review that incident report. So I do find that there is a basis for the statement.
Okay.
Right. Okay, so sir, to the charge of harassment, how do you plead today? Guilty or not guilty?
Guilty.
All right, thank you. I will accept your plea of guilty. I find that you've made it knowingly, intelligently, and voluntarily with the assistance of very competent counsel. So I am totally comfortable. And we will move on to the judgment and sentence portion. So the agreement of the parties, as I understand it, is 364 days in jail with 350 suspended and credit for time served.
That is correct, Your Honor.
And then are you asking to close the case? Is that also correct?
That is correct, Your Honor.
All right. Is there anything that you would like to say, sir? You're not required to, but if you would like me to consider anything, I'd be happy to hear from you.
I just want to say thank you for this time with me in jail. It taught me a lesson, and I apologize for disrespecting the individual and having to come in here. On my behalf, I apologize to everyone who had to take time out of their lives to deal with me in the situation. I just want to say that I'm sober and I was on fentanyl and methamphetamine and was drug induced. And so when I get out, I'm going to stay sober. And I had to go to detox for a while in jail, and it was horrible. It was a horrible time, but I got through it.
Sure. Well, I'm really glad that you were able to do that and that you've had that opportunity. I want to make sure that you're aware of the resources that are around you. So right across the street from the district court, the Pierce County District Court, there is the District Court Resource Center, and that place is available to anyone in county. And so you can go there, they can help you get housing, they can help you get into a treatment program, they can help you set up your state insurance, they can help you find a job. And I have had people go there and come back and say, oh my gosh, it changed my life. Okay, so I really encourage you to go over there so that you can get some support, because when you're in custody and you're clean and sober, it's pretty easy to say, I'm going to do this, I'm going to stay this way. When you get back out on the street and things are miserable and you are unhoused, it quickly becomes a lot harder. And so find the helpers, and the helpers are at that resource center, okay? And we want you to be your healthy and best self. And the way that happens is by finding people to give you a hand up, okay?
Sometimes it's necessary.
All right, so please make sure you go over there because you deserve to be happy and healthy, okay? I've signed off on the judgment and sentence, and I wish you well. Your hearing is complete. You'll get copies of this paperwork. You'll be released today. So if you would please tell the officers we're ready for our next guest.
Heartfelt sincerity. Thank you so much.
Thank you, sir. Bye-bye.
And just as an update for the court, I know Mr. Resnick has 2 individuals on the calendar. I have 1 individual who was in solitary prior to court today, and I waited on hold for 20 minutes and nobody ever came to the phone. So I've not been able to talk to that one person that was in solitary on for arraignment today. So I'm not sure if that person is down there, if we could do Mr. Resnick's and I could just call, and that way I don't have to do a breakout room. I see that this is Mr. Resnick's client here.
Okay. All
So
right. Well, thank you. Oh, Mr. Resnick is here. Excellent. So this is number 1 on our calendar, cause number 24L001015, the City of Lakewood versus Ronald Scott Kaylor. Mr. Kaylor is present and represented by Mr. Resnick. Mr. Resnick, go ahead and make your appearance.
For the record, Matt Rustin, council record, and it's also number 1 and 2, the ending in 112.
Yes, I'm sorry. Yeah, 24L001120. Thank you, sir.
You're welcome. Thank you. That being said, I haven't got yet the discovery or a global offer on both these cases. So I'm just spoken with Mr. Kaylor. I'm asking for a brief continuance. With Mr. Kaylor's acquiescence, obviously he's aware of it. He's on board. Mr. Kaylor did ask for me to revisit the issue of bail, but I'll get to that when you're ready to hear it.
All right, thank you. So, sir, we're going to have you come back on July 26, 2024 at 11 a.m. And this is a defense request for ongoing negotiation because he's awaiting discovery. It comes with a speedy trial waiver that recommences today. That means if you're in custody, your case would need to be resolved by September 24th. And if you were out of custody, your case would need to be resolved by October 24th. Do you have any questions about that waiver, sir?
No.
All right. And so what is it that you are requesting then, Mr. Resnick?
Mr. Kaylor, without going into a lot, because this is really not the right hearing for this, but the court can take judicial notice based on his history and previous history, as well as some other pending matters in other jurisdictions. Mr. Kaylor suffers from I guess I can say this, he battles alcoholism, and he is making the steps to get back into an inpatient treatment system. He also has figured out a place to stay temporarily until his wife vacates the family home, which should be on or about the 1st of August. He intends to bail out either way, but I think it'd be easier for him to reach out and get others to put up the money if we can reduce the bail. Other than that, I can't really say it's a true change in circumstances, but the fact that he does have, he has since his last hearing made some, and admittedly, the last hearing he had was the day after he got arrested, so he wouldn't have had time to probably make those arrangements, but he has made arrangements to stay somewhere else through the end of the month, with the assumption that his wife vacates the family home.
Okay. OOC. Yeah. Okay. All right. Thank you. All right. City, what do you have to say about that?
Your Honor, the city is requesting that the court, that bail amount is appropriate, but as to the amount the city defers to the court. The basis for this is that there was the underlying assault with the protection order that was issued, and less than a month later, there was contact that was being made. Therefore, it does give the city a pause and concern about compliance with court orders, gives the city pause and concern about keeping the alleged victim safe and secure. Therefore, as indicated previously, the city believes that bail is appropriate. It is presently set at $2,500 cash or bond. But if the court, the city will defer to the court if the court decides to lower that amount.
Okay. Thank you. I'm sorry, sir, but I cannot reduce the bail in good conscience right now. This is just looking at the history of the cases that you have been arrested and initially charged for, and then have had cases dismissed without prejudice, and all assault domestic violence cases, and then the current pending felony charges. There's a lot going on, and I'm just not confident at this point that it is appropriate to reduce the bail. So I'm not going to. I have granted that motion to continue. I wish you very good luck, both with your sobriety and with your cases. And I hope that you'll get evaluated while you're in custody and have a plan for your sobriety moving forward. I am a firm believer that much of what we see in the domestic violence realm is often linked to addiction issues as well. So you certainly can treat the larger picture by getting sober. There'll be other things required as well to move you forward successfully. But at this time, I'm not lifting the bail. So I'm sorry for disappointing you, and I wish you good luck, sir, as your life here evolves, okay?
2,500.
All right, thank you. Okay, so the out of custody, I'm going to add an out of custody get date in case you do post bail.
September 5th for conflict day,
Yeah.
if we could. Yeah, because I still haven't even gotten a new discovery yet.
Thank you.
I don't want to be unprepared.
I'm sorry. It was 2,500, correct?
Yeah, Mr. Kaylor. Yeah, you're going to be okay. And that's a good idea, Your Honor. I suspect he's going to make bail pretty soon.
All right, thank you very much. So I've indicated that if bail is posted, the next date will be 9/5/2024 at 1 p.m. I am indicating both that you should abide by all previously imposed conditions and indicating there is no change in conditions of release.
And I don't know this, Your Honor, but I know he does have court in Superior Court for something with the same alleged victim, I think on the 16th.
Okay.
I don't know if they're going to revoke his bond based on these new PC statements in this case.
All right.
I'm just kind of giving the court a heads up. He may not be around to address that. If he, I don't say I know that, but doing this a long time, I can see a few wrinkles coming down the road in this procedurally.
All right. Thank you so much. Thanks for being here, sir. I wish you very good luck moving forward.
One question. Am I still able to do what's the civil
civil
A
standby?
civil standby? Yeah. That's on the no contact order.
So I can still do that?
Yes, you can, sir.
Okay, thank you very much.
All right. Thank you. Be well.
And Your Honor, I typed this into the chat, but Mr. Spock is not able to come to court today or the phone, so we'll just ask that we be put on to Monday.
All right. So we will note Mr. Spock's failure to appear. Is it for medical reasons?
Yes, Your Honor. He's medically unable. I don't know that it was necessarily a refusal.
Okay. So I'm indicating, note, this is a failure to appear for medical reasons. And do I need to do an order, or are we just resetting to? All right, we'll establish PC, but we'll do that after we address Mr. Pleasant's case. Welcome, sir. Pardon?
Oh, I'm sorry. Maybe I'd be excused. That was my last matter.
Yes, you,
Thank you.
I'm sorry. Yes, you may. Go ahead. I'm sorry.
Okay, thank you.
Thanks, Ms. Hickok. Have a good weekend. All right, so next we're addressing number 5 on the calendar. This is case number 24L001092, the City of Lakewood versus Joshua Michael Pleasant. Mr. Pleasant is present and represented by Mr. Rusnick. Go ahead, Mr. Rusnick.
Your Honor, I'm not sure if I actually got appointed on this. I know it says that on the calendar. I was told about it yesterday when I was physically present in court in Lakewood, but there was no actual order appointing. I'm not sure if that's just as a matter of convenience that I was calendared. So I'm just, for purposes of making a complete record, requesting direct appointment if it's not, if it
All
hasn't
right,
already.
I will directly appoint you,
Thank
sir.
you. And it may have already happened. I don't know, but
All right, yes. So you are officially and directly appointed at this time.
thank
All
you.
right. So we are here for a first pretrial hearing and you're newly appointed. So what is our plan, sir?
Your Honor, I had a brief discussion with Mr. Pleasant, but again, kind of in the same situation with not the first one, but the second case, Mr. Kaylor has the more recent one in time, the July 4th case. I haven't got discovery on this matter either, which is appropriate given that either I got appointed at the very end of business yesterday or just now on the record. So they would
Okay.
not have sent it to me until there was actual order appointing. That said, I'm asking for a brief continuance, 2 weeks. And Mr. Pleasant has asked me, and unfortunately, I am a little bit behind the curve as far as background information, but if Mr. Pleasant might help us with any substantial change in circumstances.
All right. Well,
he
first,
asked
I'm
me
going to
address
say, sir, that I'm going to grant the motion to continue to July 26th, 2024. That will be on our 11 o'clock calendar. That will be a virtual hearing, and we have that noted here. And this is a motion because your attorney has just been assigned. So to best represent you, he will need an opportunity to explore everything that's going on here. This does require a speedy trial waiver. I'm setting today is the new commencement date. So the city will have through September 10th of 2024 if you remain in custody, or October 10th, 2024 if you are out of custody to address your case. And the city has no objection to that. So I'm going to grant the motion to continue. And so you wish to address all of the conditions of release? Is that correct, Mr. Rusnick?
Yeah, I think Mr. Pleasant had asked me, and again, I had a very cursory conversation with him before court this morning. I don't have all the information, mea culpa, that maybe I would normally in a motion to reduce bail. Mr. Pleasant, can you tell us about any change in circumstances that's happened?
Yes, sir. Well, I have a place.
Positive changes in circumstances. I'm sorry. Yeah.
Yes.
I do have a place to stay that's not with my girlfriend, and I have a job interview at Whole Foods on Wednesday, which I'd rather not miss, because I just moved to South Tacoma from Seattle, and I kind of had these plans. I kind of felt everything's up in the air right now. But I was hoping to maybe for a release bail to make it easier for maybe my parents to get me out so I can attend my job interview and try to get on with life while I'm still dealing with this case.
Okay. Well, thank you very much for that update, sir. But I'm sorry, I am not comfortable releasing you at this time. There is a pretty significant history of issues and challenges here that really concern me. And I am not willing to release you without significant information about what a treatment protocol will be and a confirmed place where you will be staying, so that I know that you are in a situation where you are well supported. Looking at the past, there have been charges that were dismissed on competency questions and concerns. And so I want to know that there is some help and support in place for you before we let there be a change in circumstance, okay? So I'm not going to change the bail requirement. A review of the docket, I'm not seeing what bail is presently.
I believe it's $5,000.
Okay, it's 5,000 cash or bond. Okay, so I am not going to change that, but I'm granting the motion to continue. I am ordering that you continue to abide by all of the previously imposed conditions, and I am indicating that bail remains at $5,000 cash or bond. There is no change to the conditions of release. If you do post bail, your out of custody date shall be September 5th, 2024 at 1 p.m. at the courthouse. Okay? Thank you very much for being here. I wish you well, sir. And I would encourage you to figure out what some supportive housing opportunities might be, so that a change in bail might be considered. Okay? All right, I wish you very good luck, and you're in good hands with Mr. Rusnick. So I am sure that this will begin moving forward much more efficiently, okay? All right, take good care. You're excused from the hearing. We'll make sure you get copies. I need Mr. Rusnick has signed, so I'll ask you to sign, Mr. Vinson. All right, thanks for being here, Mr. Rusnick.
Thank you, Your Honor. Have a good weekend. You too, Mr. President.
Bye-bye. All right, and then on number 6, we do need to establish probable cause. And can we take the camera off so I can take this off? Yeah. Thank you.
In 10 minutes, that kind of thing. So that's where we're at with some of this. Some email traffic indicates the text box, like what text do I want, what font? And it's like,
that's weird.
Go to where I can print in. I am on Nisqually today. All right. I'm just getting back to Will. I don't want him to worry. Okay. Okay. Jail today. Dorsey Johnson.
Are we
Yes.
streaming the court? I mean, I think my recommendation is appropriate if you look at his history, but
write it up and we'll do it. I just got done pulling all his stuff. It's like 4 charges. Come on, dude. Oh, I should tell you about another one that's going to hit you guys, I think. Do you guys have Certeza Johnson?
Yes.
Okay, she had 4
hold on.
more.
Judges on the bench.
Oh, all right. Good. Thanks.
Hi, welcome to the Nisqually jail calendar for August 5th. Just wanted to hop on at 1 and get an update from the parties.
I do not see Nisqually logged on. So.
Okay.
Your Honor, we've gotten some traffic, some email traffic indicating that the jail has been asking, it looks like Miss Hickok to call them back at different times. Like, we're not ready now, try calling back in 10 minutes, that kind of thing. So that's where we're at with some of this.
I will and Your Honor, just to kind of update on that, I was able to get a hold of them at 12:30 and they had most of the people pulled. And so I was able to talk to probably 3 of the 8. And then I had to log in for this. So I'm not sure what's going on down there today.
Right. Well, I don't see Nisqually now. What I'm going to do is, I'm hopeful that we can move on a few from 3. I'll come back in 10 minutes and see where we are. Hopefully we can move ahead. All right, thank you.
Thanks. So, are you there, Amelia?
I am.
Okay, we can talk about that other one later. I've got this,
I just want to make sure the judge is not able to hear us. Because the clerk, I don't want us to be talking and have it everybody.
Oh, yeah. Do you want me to just direct text you? Because I just want to know.
That'd be wonderful. You can either text me or email me. I'll be looking
I'm just going to, yeah, okay.
Okay.
we'll do that.
Actually, Heidi, if you want, we can join a breakout room and just talk because nobody's in here from this wall. You want to join breakout room 1?
Yeah, that'd be great.
Okay.
Don't know how to go there. How do I go there?
Got it.
Okay, who do we have in the squally?
Your Honor, this is Billy Valle, VALLE, cause 24L1319 on for arraignment.
Okay, and sir, your name is Billy JW, it's Valle?
Yes.
Okay, and date of birth, March 31st, 2003?
Yep.
And then are you still on or receiving mail at Gravely Lake Drive?
Yes.
address. Okay. Counsel.
Your Honor, with respect to his arraignment, we would acknowledge receipt of the complaint, waive a formal reading, ask the court to enter a plea of not guilty on his behalf. I'll stipulate to probable cause for the purpose of setting pre-trial release conditions today. In speaking with him about his income, it does sound like he's bringing home between $3,000 and $5,000 a month and does not have any dependents. So I informed him he'd like.
I cannot appoint counsel. I'll hear from the city. Okay, you're on mute, please.
We have had contact with the alleged victim in this matter, and she is not wanting a no contact order. She is potentially not supportive of the city's prosecution of this, which doesn't always carry the day for the defendant. We have referred her to the Crystal Judson Center for additional support should she need it. But that being the case, the city is willing to release Mr. Vallier on his promise to return. And during that time, he needs to maintain law-abiding behavior, because if there are any similar incidents or problems, the city will be asking for bail in that instance.
Any objection?
No objection, Your Honor.
Okay, sir, I'm going to release you today and set an out of custody hearing. So you come back to Lakewood Municipal Court. You know where that is?
Yes.
Okay. So you will come back on September 10th at 1. And between now and that time, please retain an attorney so that they can be ready to represent you. Have no criminal law violations. Update any address changes immediately with the court. And I want to stress that if you move, the court corresponds with you through mail. If you don't get your mail, you miss court. If you miss court, you get a warrant. Do you understand?
Yes.
So that's important. Use only your true legal name and date of birth. Okay, I'm saving that for signature.
And I've signed that, Your Honor.
Okay, I'm marking served on defendant and I'm signing. Is there anything else in this matter?
No, Your Honor.
All right, so you may be excused, sir.
Thank you very much.
Thank you. What is your name, please?
Darcy Darnell Johnson Jr.
And this is one I need a breakout room on, Your Honor.
All right. You have about 3 minutes.
Okay, it's a plea that I need to review with him, and I wasn't able
Okay.
to.
5 minutes.
Quick though. Okay, thank you. And then Nisqually, if you could join breakout room 1, that would be great.
Yes, ma'am.
Take a recess. Okay, 1 moment, please. Okay, counsel.
Your Honor, I apologize. I'm just finishing the wording of the plea paperwork. So he's pleading guilty as charged. Mr. Johnson's pleading guilty as charged to 1 count of physical control and 1 count of assault 4th degree domestic violence. I have gone over the agreement in full with him. I believe he's making a knowing, intelligent, voluntary waiver of his rights. We did discuss any potential immigration consequences, and I believe he's ready for any questions that Your Honor may have of him, and I can exit out of the document just a second here. And so the plea paperwork should have that pursuant to plea, the city should be moving to dismiss both of the hit and run attended vehicle charges in 24L46, as well as 24L917 and 24L633. And I can just finish filling that out, but I do believe he's ready for Your Honor's call.
Okay, Mr. Johnson, can you hear me okay?
Yes, Your Honor.
Did you have enough time to talk to your attorney about what you're doing today?
Yes.
Hey, do you understand I don't have to follow anyone's recommendation as to sentence? I could impose any sentence up to the maximum in this case. And for the cases that don't have a motion to dismiss, maximum would be 364 days in jail and a $5,000 fine for each. Do you understand that?
Yes.
Okay. Do you also understand that you will not be having a trial in these matters?
Yes.
That means that you will, 1 moment, that you are giving up your right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You're giving up the right to remain silent before and during trial and the right to refuse to testify against yourself, the right at trial to hear and question witnesses who would testify against you, the right at trial to testify and have witnesses testify for you. These witnesses can be made to appear at no expense to you. You're giving up the right to be presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, which this is. And you're giving up the right to appeal a finding of guilt after a trial. You understand those rights that you're giving up?
Yes.
Okay, do you also understand that if you're not a citizen of the United States, a plea of guilty might make you vulnerable to deportation, exclusion from the U.S., from the United States, or denial of naturalization?
Yes.
Is anyone forcing you or threatening you to do this today?
No.
Okay, I will read what is known as statement of defendant on plea of guilty. It says, on July 26, 2024, in the city of Lakewood, I had actual physical control of a motor vehicle while under the influence of alcohol.
I'm sorry, Your Honor, I'm just taking in the last statement here after getting the.
Ms. Hickok is doing that. Ms. Wachter, do you know if there are any bonds on these matters or no contact orders?
Your Honor, I'll have to check on the no contact orders. Let me just, there's a couple different files here in front of me, so I will check.
Okay, I'll read it again. This is in paragraph 11 of your guilty plea. On July 26, 2024 in Lakewood, I had actual physical control of a motor vehicle while under the influence of alcohol. On June 27, 2024 in Lakewood, I knowingly and intentionally sprayed pepper spray, causing injury to Natasha Johnson, a family or household member as defined by state law. Are those true statements? I can't hear you.
Yes.
And to the charges of physical control and assault in the 4th degree DV designation, how do you plead? Guilty or not guilty?
Guilty.
I'll accept your plea of guilt, finding that you're entering into it knowingly, voluntarily, and intelligently, and that there are actual adequate factual bases for this plea. I'll now hear from the party. City?
Yes, Your Honor, pursuant to your previous question, it looks like we sent a no contact order along with the victim impact statement in June. By July 16th, the alleged victim was specifically requesting the no contact order be lifted as she was moving out. So it looks like the court declined to do that in July, but indicated that she may come back to modify after she moves out. And we haven't had further contact from her, but based on this plea, we would think that the no contact order should be lifted.
Okay, anything from the city?
From defense, Your Honor?
I mean, defense, thank you.
Yes, Your Honor. So if you recall, we were in front of the court in July. Mr. Johnson was out of custody at that point. We heard from the alleged victim who indicated she had no concern and wanted the order lifted pursuant to plea negotiations. This would involve a plea with no new post-conviction, no contact order. I would ask, Your Honor, that you follow the recommendation. It was heavily negotiated by the parties. Alcohol is the main factor behind all of these offenses, and he specifically mentioned in the police report involving Natasha as well. He understands that he has a problem with alcohol, and it's something that he's working on. He's on a DOC hold right now, and they're also monitoring him for compliance with alcohol treatment. He's been in and out of treatment and realizes it's something that he needs to get back going on and stay sober. And so I would ask that you follow the recommendation. It's for standard conditions on the physical control. He knows he's to obtain an updated alcohol evaluation. The mandatory minimum on that physical control with a BAC is 48 hours, and he has done 9 days on that.
Okay, and then what was the BAC?
It was over a 0.15.
I'm putting it on the JNS, that's why I asked.
Yes, I can get it pulled up, but it was over a 0.15. I know that. Let's see.
I'm looking at it right now. I'll let you know if I come up with that. Your Honor, according to this is from the Draker Alco test. The first sample was a 3131 and the second sample was a 3333.
That's amazingly high.
Yes. And Your Honor, I explained to him that he's going to be on probation with our court for 5 years on both of these charges, and there's a lot of jail time hanging over his head if he chooses to reoffend or not get and stay sober, as we're asking of him.
Okay, and is there anything else that you wanted to say, Ms. Hickok, before I move on to the city?
Just that with respect to fines, he's not currently working, has no source of income right now, is working on being sober, and so we'll ask the court to not impose fines in this case.
Okay, and I will move to the city.
Nothing further from the city, Your Honor.
Okay, sir, you don't have to say anything to me, but if you wish to have me consider anything before I sentence you, now would be the time to share.
I just want to, say that I'm very disappointed in myself because I know I'm way better than this, and I just want to get back home to my family. I take care of my 96-year-old auntie. She can't walk. She's very disappointed in me right now, and I just want to get out here and just show my family and get my family back together and show them that I can overcome this alcohol addiction that I have, and I could be a better person for not just me, for I got a lot of children in my neighborhood that look up to me, and it's very disappointing to when the police come and they arrest me and the kids see me getting arrested. I don't want to see them me in that light, and I apologize to myself and my family. And Your Honor, if you can please honor, our deal, and I'll hold up on my end of the bargain. I just want to get back home to my family and get myself together.
Okay, thank you. I will say, I think you're off to a good start because you have an understanding that you have an addiction and that you need to take care of it. Okay, so to me, I've seen a lot of alcohol-related infractions and crimes, and it bodes well to know that you have accepted what is a reality, and you're willing to move forward, getting the help that you need, because there's tools out there. All right. Also, you can work to put this behind you. And you can be an example to your family and show them that you take your responsibilities seriously and you don't let that stop you from moving forward. Okay, that said, my sentence is as follows. We start from the top. Cause number 24L/00046, the hit and run attended, is dismissed with prejudice. So there's two charges of that under the same cause number. The second charge of hit and run under cause number ending in 046 is dismissed with prejudice. The physical control under cause number 24L/0001266. It was an acceptance of a guilty plea, 364 days in jail with 355 days suspended, credit for 9 days served, fine $5,000 with $5,000 suspended. And I will let you know, I uploaded a DUI judgment and sentence instead of a regular judgment and sentence.
Thank you.
The jurisdiction is for 60 months. Okay, under cause number 24L001083, that too is dismissed with prejudice. Cause number 24L000917, assault in the 4th degree, is also dismissed with prejudice, as is cause number 24L000633, dismissed with prejudice. Is that right? Does that reflect the parties?
So, Your Honor, he's, with respect to the assault case, he pled to the one ending in 1083 and the other.
Okay. Okay, I hit the blue circle and that's what came up, but I see now. Okay, so that is 364 days. That's cause number 24L001083. And that is 364 days with 362 days suspended, $5,000 fine with $5,000 suspended, jurisdiction for 60 months. Okay, and then the assault in the 4th degree ending in 917 is dismissed with prejudice. That's correct, right?
Yes, sir.
Correct, Your Honor.
As is the harassment, cause number ending in 0633, dismissed with prejudice.
Correct, Your Honor.
I'm rescinding the no contact order in this case. Were there any bonds?
That I do not know from what I've been looking at.
I'm going to let you know, sir, that you're not to drive a motor vehicle without a valid license and insurance. Do not drive or be in physical control of a motor vehicle with an alcohol concentration of 0.08 or more, or a THC concentration of 5 nanograms per milliliter of whole blood or higher within 2 hours of driving. You shall submit to a breath test or blood alcohol test upon the reasonable request of a law enforcement officer. Shall not drive a motor vehicle without a functioning ignition interlock device as required by the Department of Licensing. I'm going to ask that you have no criminal law violations, no alcohol-related infractions. I'm going to ask that you do not use or possess alcohol, non-prescribed drugs, marijuana, or drug paraphernalia. I'm going to ask that you obtain a substance use disorder evaluation within 90 days and begin any recommended education or treatment within 120 days. Complete and submit proof to the court within 90 days of a DUI victim impact panel. Okay, I am going to ask that you report to court security and the parties are not asking for alcohol monitoring in this case? Okay.
Correct, Your Honor.
All right. I'm going to ask that you have ignition interlock device installed within 5 business days of this order.
And Your Honor, since it's post-conviction, I think it would be just my request would be that it would just be ignition interlock as required by the Department of Licensing, since it's no longer trial.
I'll hear from the city.
Your Honor, I would concur with that. I think that one of the things we're hoping for here is that Mr. Johnson is taking care of all of his matters. They all relate back to one thing, and we're going to try to keep it simple and get through it. He's going to be dealing with the alcohol issue.
Okay, so you are just to follow rules and regulations of the Department of Licensing regarding the installation and use of a functioning ignition interlock device. What you don't want to do, sir, is go out and drive without the ignition interlock device and get pulled over. Okay, that's going to be really important moving forward, because that's a whole other criminal charge. Okay, did we find out about the bonds?
Your Honor, I'm not sure where to find that. I don't have it indicated in my file, and I don't see it indicated in the case history. So,
He had bond posted on every case, had posted bond through a bail bonds company on every matter except for the physical control, which he not posted bond for. So all of the cause numbers, and I can.
So is defense making a motion?
But asked to exonerate the bond on all of those.
And there's no objection to that, Your Honor.
Bonds are exonerated in these matters. Right, and with the assault 4, my understanding is that we need DNA.
Yes, Your Honor, as he was convicted of that assault 3, there should be DNA on file through DOC. But I did also go over his loss of right to own a firearm.
Okay. So DNA should be on file. So I won't set up a time for you to come in and do DNA. Okay, and I will also ask. Okay. That you have no firearms. I'm not sure if this is on the DUI judgment and sentence, so I'll write that out. And as far as probation, what were the parties anticipating? I was thinking 60 months of monitored probation.
Yes, Your Honor, I think that is the requirement. Would ask that it just be unsupervised and that we give him a date to come back for review hearing so that he can show the court he's in compliance.
The city's in concurrence.
Okay, and as far as the review, date, I'll hear from the parties.
I think either 60 or 90 days, Your Honor, whatever the court has available. We anticipate he'll be released on his DOC hold tomorrow.
Oh, okay. So I'll set a 90-day review on October 31st. And that's October 31st at 10 a.m. Okay. That's here in Lakewood Municipal Court. Do you know where that is?
Yes.
Okay, and so there's a little glitch on, I wanted to let you know, there's a glitch on cause number 1083, the assault 4. I had hit the populate button and previously it came up as dismissed. And then that was not correct, but I cannot erase with prejudice. Okay, I'm just going to note that he's been previously convicted of assault 3 and DNA should be on file.
And Your Honor, I think that's likely something we can double check as well with Officer Lamelli on or before his first review hearing, just to verify it's on file, but that should be there.
Okay, I'm not really understanding. Check with Officer Lamelli about what?
I'm sorry. So in cases like this, Officer Lamelli has been able to check for us either on or before the first review hearing. She has access to that information. So maybe we could make a note just to have her verify.
Okay, but I'd rather have that verified before we sign off on this. Just one moment. Oh, Daisy's not here. I mean, Officer Lamelli is not here. This is what I'm going to do. I'm going to ask that Nisqually collect it before he's released because I just don't know for sure. Okay, I'm going to save this document. There are a lot of charges and a lot going on. Please review this carefully.
And Your Honor, as I look over that, I also uploaded a firearms order on sentencing.
Yes, I'll review that.
Great, thank you.
Okay, sir, because you've been convicted of assault 4 today, you must immediately surrender all firearms and any concealed pistol licenses you may not possess, own, or have under your control a firearm And under federal law, any firearm or ammunition or concealed pistol license until your right has been restored. Violation of these laws is a felony pursuant to RCW 941-040. And I'm signing that. Marking served on defendant.
Your Honor, just a couple of things. I did mark that defendant released on one of the dismissed charges, and it looks like there was a typo in the BAC, so I amended that to the .31, which is what Ms. Wachter read into the
Okay.
record.
Thank you.
And then, yes, and then for the matter, the assault for, it looks like ending in 1083 is marked dismissed, but that is the one that was a conviction. So I'm going to delete that dismissal.
Yeah,
and
I
then-
was having a hard time erasing that. Maybe
That
you
should be
can.
fixed.
Okay.
Yeah.
Thank you.
Everything else looks correct to me, Your Honor.
I think I'm going to mark do not possess or own firearms. Even though we have that other order, I'm going to put it on the judgment and sentence.
And then the bond exonerated box underneath.
I'm sorry, what?
The bond, bail bond is exonerated. If we could check that box right underneath Nisqually jails to collect, just toward the very end of that. It's right above the collateral attack information.
Okay, hang on. Okay, I'm not seeing that. I wrote it out, but I'm not seeing the box.
Here, I can check it, Your Honor. Just checking right above. I have read the rights, conditions, and warnings, and checking bail bond is exonerated. Save that. You can have the signature as well. I've signed, Your Honor.
Okay, and city, have you reviewed this document?
I have reviewed the plea of guilty, Your Honor, and I'm reviewing the newer document now. And I've been tracking along, and we're satisfied that it's appropriately filled out and reflects our agreement. As you know, there were several charges going on here. And I think Miss Amelia is commendable for keeping track of it all.
Yes, and I do now see that bail on bond check. Okay, and then so we'll await your signature, Ms. Wachter, and we will conclude this matter.
And Your Honor, it does look like your signature is not on the guilty plea form.
Oh, okay, thank you.
Ms. Walker's signature.
We'll take turns. All right.
Marking served on defendant. Go ahead and get out of the document if you would.
Thought that I had.
I'll refresh, maybe you have.
Yeah.
Okay.
Sorry about that.
It's okay. And I'm signing. All right, sir, good luck to you. Just keep going forward. I know you can do this.
Thank you, Your Honor.
You're welcome.
Thank you, Ms. Hickok. Thank you, Ms. Washington.